just so that we're all on the same page, and you all can correct me if I'm wrong, we have, I believe one of the first filings after the court's order was the defendant's motion to require privilege log and in-camera submission of withheld communications and to clarify the meaning of victim support communications, which I'm just going to short title that as like a motion for clarification. And then I have the state's response to the defendant's motion to require privilege log and in-camera submission, or the state's response to the motion for clarification. Then I have the subpoenas that were issued pursuant to the court's order that then Ms. Bridegan, Mr. Clifton, you filed a motion for protective order, which is part of the pleadings to, I guess, express concern on part of Ms. Bridegan related to the subpoenas. Is that everything? All right, am I missing anything? Okay. All right, so this is the way I read the papers. I believe that I need clarification from the state of Florida, because I left it open to the position of the state of Florida whether you wanted to, I guess, produce some of these things and then take it off Ms. Bridegan's production request from the defense. And so I need an answer to that, Mr. Siegel.
Your Honor, as I understood your order, you indicated that it would be too intrusive based on the present record to require the state to produce the victim support communications as well as the work product. So I did not review or see your order as being a directive to the state to produce those. Those were just simply set to the side. But the short answer to the court's question is no, those should come from Ms. Bridegan.
Okay. All right, so I believe that, so now the state's position is that you would not be producing anything that may be contained on devices of the identified state attorney and assistant state attorneys. So then I would have to go, I didn't believe that it was necessarily ripe. And so as it relates to the defendant's motion to require the privilege log and in-camera submission, Ms. Nelson, I want to know what, if the state of Florida's position is that they aren't going to produce any of those communications or the subject of the subpoena that was directed towards Ms. Bridegan, what, do you believe that that's now moot?
It is moot, Your Honor, insofar as there are no communications being withheld. If Ms. Bridegan or the state has also asserted statutory standing on her behalf, so it's not clear exactly to whom I should address this, but I'll assume it's Ms. Bridegan and Mr. Clifton. To the extent that no communications are being withheld as either work product or as victim support communications, then I do believe our motion is moot. But if anything is being withheld, we're simply asking that we have the opportunity to know what's being withheld and to be able to challenge those claims of privilege under Callaway. And that's the request.
Okay, so the way that I read it, okay, I don't believe that Ms. Bridegan can assert any type of privilege. So if the state is saying we aren't going to produce it, then I don't think Ms. Bridegan can assert a privilege. That's the burden of the party. So Mr. Clifton, so then I believe now your motion for a protective order would be ripe related to Ms. Bridegan's interests.
Thank you, Your Honor. And Doug Clifton on behalf of Kirsten Bridegan. Is it all right if I take this off?
Sorry?
Is it all right if I take this off?
No.
Okay. It just seems loud.
No, it's necessary because otherwise they can't hear you.
Okay, all right.
You can clip it somewhere else, though.
Your Honor, there's two things in our motion specifically, and one that I didn't put in there, but I do want to address with the court. Number one is just, we didn't think anything in your order was demanding that Kirsten Bridegan provide anything directly to the defense.
Right,
We
no,
believe everything should go to the judge. If there's anything to be provided to the judge, it goes to you first and not to them. Their subpoenas were saying, this comes to us, this goes to the judge. And so part of that is as
Hold
far as
on.
their subpoenas.
So stop there. I don't know that I necessarily read it like that. Hold on.
In item A1,
Okay, I see.
yeah, to undersigned counsel, and then B3 to undersigned counsel.
Yeah, okay, so in my order, I didn't find, I believe that is call logs, if I'm not mistaken, Ms. Nelson. So I
correct.
don't need to review call logs. Like, they don't contain anything. It's just,
Well, and I guess that kind of leads into my other point, though, is we don't have the call logs. You know, and I mean, so there's, you know, to put the burden on Mrs. Bridegan to somehow download her own data, like, we don't have that capability unless we're going to go out and pay for something, and to put that burden on her was just, that's the next, kind of the next step in what we're
well,
arguing.
let me pause you for a moment. Ms. Nelson, I thought, like, okay, correct me if I'm wrong, okay? I thought in somehow in one of the pleadings, I have not read the second deposition, but I thought that Ms. Bridegan said that she had, like, in and out, you know, from her phone, like that she called the state or whatever. That's what I thought. And then those questions were asked. The defense said they didn't have the time. I thought that was part of it, no?
No, Your Honor, there were questions regarding whether communications happened. She said, yes, they have. There were questions regarding the amount. There was information that she put together for her second deposition in accordance with your order. That's been compiled. This, though, is stating, I mean, I think it was basically 4 years of call data. That's time, date, and everything else. We don't have that. That's not something that's been put together by us. That's something that would have to be done forensically and taken off the phone. And frankly, Your Honor, they should have subpoenaed the carrier 2 years ago and gotten that information, or a year ago. Now we're right on the eve of trial, and they're demanding it from her. That's not the normal process of that. Every lawyer just goes out and gets it from Verizon.
Okay.
So that's on them as far as creating this bottleneck.
Well, they can only subpoena what you have. And so if you don't have it, that's the response.
We don't have it unless there is a forensic download of her phone. We don't have call log data that we can just provide.
Your Honor, if I may, a few points to make here. So first of all, we have a forensic vendor who has been court approved in Florida as being neutral, joining us by Zoom today. Ms.
Is that
Bridegan,
Mr. Green?
That's correct, Your Honor. Jake Green from Invista Forensics. Your Honor, previously Ms. Bridegan had opposed any sort of forensic vendor. We proposed this back in July. And so here we are again with delays being caused by switching positions. And so we are just trying to get the discovery to which the court has said we are entitled. This was due yesterday, according to the court's order. We still have not received it. We have proposed solutions. We've been seeking this information since February of this year, and we're still here in August seeking the same information. If we had known back in February that the information didn't exist, despite Ms. Bridegan's testimony under oath that she has not deleted any information from her cell phone, we would have gone out and sought a subpoena from her cell phone provider. However, her sworn testimony was, I have not deleted anything. All of this information is on my phone, and I would not oppose somebody coming to get it. But here we are months later, still facing opposition. All we're asking, Your Honor, is we are seeking solutions. We are seeking to implement the court's order about what we believe we are entitled to and what the court has found we're entitled to. We're asking the court to order that Ms. Bridegan produce her cell phone this week to this court, for Invista Forensics, in order for us to get the information that has been ordered by the court. Mr. Green, please correct me if I'm wrong, but I believe Invista would be able to forensically image Ms. Bridegan's cell phone no later than Friday of this week.
Yes, ma'am. We could have somebody in Jacksonville tomorrow.
Your Honor, if I may, I mean, those are just misstatements. we weren't here in February arguing about subpoenas for phones or anything on the phone. Their first motion after this deposition in January was later and was just asking for a second deposition. So these are all misstatements. And as far as I know, this provider of theirs is actually working with them on this case. Like, that's the whole point. We're not just giving our phone to the defense so their guy can download everything and we're just all supposed to go along with that. That's beyond the scope of what's going on here. And I know that there was an in-camera review of materiality and everything, but we're still in the dark on what exactly is being looked for. They're asking for, and I'll just get into it now, every single direct message on Instagram. Is there specific individuals that they want? I mean, that could be numerous, and that's an invasion of her privacy. And they've had these Instagram. The only thing that's not public and that they can't recover themselves right now is the stories. Those stay on for 24 hours and then they're saved on
The
the
stories.
Instagram has stories.
Okay.
And that's a 24-hour thing. Her site is public. They can go through it. They can pull all the comments. They can pull everything they want off it. So I understand
But
the story.
Mr. Clifton, my understanding, at least from the pleadings, is that there was a point in time in which it was public. Then there was a point in time that it was pulled down at the request of the state, and then it was put public or something. Am I wrong about that? Like, I thought I read that.
There was a time where it went down and then it's back up. I mean, it's been on for years. I went through it this morning. There's comments, there's posts, like, they're asking, and that's another thing I wanted clarification. They're asking for direct messages. That's private messages that she's having with anybody else. If there's not a specific person involved in that, that's an enormous amount of information. That's phishing, and that's an invasion of her privacy and harassment.
Your Honor, if I may be heard, Mr. Clifton is attempting to relitigate our original motion. This is our 6th hearing on this issue. The court has found materiality. The court has found particularization as to specific communications, which are outlined in the court's August 11th order. We're not asking for anything more than what the court has authorized, and any sort of attempt to recast what we are seeking is incorrect. And I want to correct the record and be very clear. We sent a letter to the state on February 6th.
Wait, let me interrupt you, Ms. Nelson. So I'm looking back at the order. These arguments that you're making, Mr. Clifton, I have settled them, I thought. I said no sweeping requests for all direct messages, account settings, viewing history, metadata. Instead, I said the narrow request of legal theories, statements about defense counsel, statements about guilt or innocence, instructions, that is what they would be allowed to do.
Direct messages concerning defense counsel, defense team, or defense guilt or punishment, that's basically, when you say that, it's just Justin for Jared's site. That's what it's about. It's about this trial. I think everything can be concerning guilt or punishment. And to have her go through all that and try to figure out what is what.
I don't think that she needs to self-edit. So if there are messages, and that's why I wanted the hearing. The papers have, like, they keep flowing and flowing and flowing, right? The initial request was centered around, there is no mystery about that. They put it in the initial pleading, which is disparaging comments about defense counsel.
Those were on a story that they have. I mean, you understand, like in January, they questioned her about those specific comments, and she said, yeah, I made those.
Right, and then, so I put to bed that issue. Now they are seeking what may not be, that might have been related to that particular disparaging comment.
So is anything that Mrs. Bridegan then said and anybody else in a private message on Instagram, all that's discoverable?
No.
That's what direct messages are, though. That's what that means.
No, I would go through them in an in-camera review, and I would only disclose what would be within that parameter. I'm not asking you to self-edit.
Are we going to have an opportunity then to see what's going to be provided to them and object again? Because I still don't understand what the materiality of direct messages are. That's private messages she's having with somebody, and somehow that's relevant to her testimony? I mean, again, I know we're in the dark on a few things because there was that in-camera materiality argument. I don't know what they provided to you, Your Honor, but I do know that going through direct messages, just private messages of hers, where does that lead? I mean, that is nothing but a fishing expedition. If you're saying we want a private message that she sent to EF or this particular person because that's material, okay, then maybe, you know, I get that. This is just, we want every direct message for 4 years. That could be thousands. That, I mean, so there just needs to be a narrowing down. If there is materiality to it, that is a very broad spectrum of information that she has to hand over.
Your Honor, if I may offer a limiting principle, which I believe the court already contemplated in its order, and that is due process and to discovery under the rules. We believe the court has struck the right balance and put in place the correct procedural safeguards. We're asking this court simply to effectuate its order and to require Ms. Bridegan to comply.
So I'm going to read the order again. I said, this court grants a targeted in-camera review of Justice for Jared content consisting of posts, comments, and direct messages concerning, these are the categories: defense counsel, defense team, defendant's guilt or punishment, and then any communication about stopping, editing, deleting, and that came from the state, the initial pleading that said that the state said take it down. This court has found the materiality of it, and I understand the burden for which this places on Ms. Bridegan. I can foresee any number of ways to take it off of her. The state of Florida doesn't want to do it, and I don't think that I can order them to do it.
No, but you can, and there needs to be a neutral party that's going to do it. The defense needs to pay for it, and then we would still like the opportunity before anything goes to the defense to offer objections. He works for them.
He does not work for us, Your Honor. He has assisted with this case. Invista Forensics is an independent third-party contractor that the defense has contracted with, and as I said previously, has been found by other courts in Florida to be a neutral third party for forensic purposes. I apologize, Your Honor.
I'm sorry. Go ahead.
I'm not hearing any solutions being proposed by Ms. Bridegan, only objections. Ms. Gardner is here offering solutions. We initially offered a forensic vendor. They said no. We asked then, okay, please direct her to produce, and now they're saying no. We came to court with a forensic vendor to propose to the court. They're still saying no, but they're not offering a solution. Your Honor, what we're asking for is simply that this court order that Ms. Bridegan comply. If they want to propose a third-party vendor by noon today, we're willing to meet and confer with them. We also disagree that Invista is not qualified to do so. They're professionals, Your Honor.
Your Honor, Christina Stifler for the state. I'm not speaking on any of the issues other than Mr. Green. In just my experience, Ms. Nelson joined the case relatively late in the proceedings, but I have been in contact with Mr. Green for a number of years. He's been retained by Ms. Gardner's defense team as an expert and or consultant. He's gone through all of the discovery. He's rendered them opinions. He's participated in litigation in the disqualification proceedings. So just to give context to Mr. Clifton's argument, he is not an independent. He's a part of the defense team, has worked on defense strategy, and has had access to all the state's electronic discovery in the criminal proceeding. So, I mean, I can get with Mr. Clifton and propose perhaps seeking somebody else who has forensic capabilities to do so, whether through law enforcement agencies that are unrelated to this case or otherwise. But I just wanted to clarify that I do know Mr. Green has worked extensively on this case and has had access to state's discovery and defense strategy for years.
And Your Honor, we did provide a manner of compliance. That is our suggestions. As much as the defense would like to say it's not, but we just want a neutral provider She can provide her phone to them. The information will go directly to you, nothing to the defense yet. And whatever happens then, we would want the opportunity to provide objections to anything that's going to be provided to them, because we're still left in the dark.
Okay.
Your Honor, we have a proposal. JSO has the capability to do this today.
As long as they're not busy.
We would propose that JSO be directed to
Wait.
complete the forensic.
She can't hear you. Go ahead. I'm sorry.
I apologize if somebody else was speaking. I couldn't
No,
hear.
it's okay. Let me hear you. Okay.
Thank you, Your Honor. We would propose that JSO complete the extraction today, and that then be produced to the defense consistent with the court's order not to the defense. The categories that were ordered produced in camera be produced in camera to the court to the extent that they haven't already been produced. They were due to be produced yesterday. And then the specific call log metadata issue, which was ordered produced directly to the defense, that be produced directly to the defense no later than Friday. I would imagine it could be done today, Your Honor, but we're willing to agree to a production date by Friday for that which is due to the defense.
I don't know. I don't know that JSO can do it, but let me ask this. All I can do is ask at this point, because this is a subpoena to a non-party. The state is taking a position of basically not facilitating. I don't know if I don't want to call over there. Maybe Ms. Nelson, you can call over there. Would Ms. Bridegan have an objection to JSO imaging the phone?
As long as any information is going to the court first, Your Honor, there's no objection to that, but then we would still want an opportunity to object to anything that's going to the defense.
Well, I ordered that the call log go. I don't know.
That's the what? Call, time, data, date, duration?
Right, like something they could have gotten from.
Should have gotten from Verizon or whomever.
Right, like
months
the
ago.
in, out. I don't know that she would have any privacy right in that, like just.
No, I agree, Your Honor. So if
So that goes to the defense. I've ordered that. So, but the other is substantive. I have to do an in-camera review. I have to make sure that it's not impacting her privacy rights related. And maybe I was inartful, but victim support communications. I've got to. I'm sure they have. That is, the defense wants to litigate what that means, and what I mean by that is the Constitution, Marcy's Law. That's what I mean. Ms. Bridegan has a constitutional right to communicate with the state of Florida. She has a constitutional right to consult. She has a constitutional right, so all of those, while not privileged, she has a constitutional right in that level of communication with the state to be informed per the law. So that's, maybe an inartful word, but, I don't know that crosses the line into what the defense has shown to be material in this case. She shouldn't. She should be and feel comfortable and confident that her constitutional rights are also guarded. So I try to strike that balance. But I do understand the calls in and out and in. I think they get it. They get it directly. But I don't know how to effectuate it because, and I want to know from you, Mr. Clifton, what is the difference between picking someone and then they get paid by the defense?
Because they won't know the defense. This is somebody who's familiar with the defense, Your Honor. I mean, we're just not comfortable at all handing over a phone to somebody who is hired, paid by the defense as an expert in their case.
Do you know someone?
But there are other forensic, there's capabilities around Jacksonville.
Do you know someone?
I could find somebody. I was hoping the court had somebody in mind.
Mr. Clifton, I deal in criminal law. Like the only person I see up on the witness stand is JSO.
I've never had a client have to have their phone dumped. I mean, this has never happened. So I'm in a new territory.
I have been searching like any case that would give me some type of guidance. I am walking in total gray territory. I'm doing my very best, okay? Like, I think we're all out there somewhere.
I think the biggest concern then, I mean, I understand and they're trying to put deadlines on things. This was supposed to happen yesterday. That's their subpoena was yesterday. We ignored that and objected to it. The timelines on things, I mean, it might take a little longer than Friday to get them everything they want, or Friday for the court. And frankly, Your Honor, Mrs. Bridegan, this trial is happening right now.
I agree. And
it's just going back to the burden on her for doing all this, but I understand, and I will take the burden of hopefully trying to find somebody to do this for us. But again, and I think where you were on the right track talking about constitutional rights, the other constitutional right in Marcy's law is that she has to be heard at anything regarding her rights. And again, before anything goes to the defense, we want to know what it is and offer objections to it, because we are again in the dark on materiality of really specifically DMs and that kind of thing. But we'll get into all that. I mean, again, because that could be, Your Honor, that could be thousands of messages. I mean,
I have no idea.
That's called a fishing expedition. I mean,
I am also in this trial. I've got to be present and thinking, and I wanted to try to resolve this issue. I don't want to, and I understand both sides, and I am very, very cognizant of the constitutional rights of both Ms. Bridegan and the defendant. I've got to strike that balance, and I'm trying. So what I would ask, I'm not ordering, I would ask, can the state of Florida please contact JSO and see if they would be willing to do it? If they are not, then I'm going to put it on Ms. Bridegan, unfortunately, okay? And then you propose a name of somebody. I don't know. That's who sits in this witness stand day in, day out. Okay, it's JSO.
well, who's going to pay for that then, Your Honor?
Your Honor, our firm has used Mulholland Investigations many times for that purpose. I don't know.
Mulholland?
Mulholland, they're local.
I know him. I actually know Mulholland.
They do that work. I've used them for downloads all the time.
Can you get me the information, please? Can someone vet it for me? Like, how, I want to know how long they believe that it would take. Can they set the parameters that the court is? I don't want her whole phone dumped. That is against the law. And there is a way, I think.
I will talk to the expert, see if there's a way to do it as it's described here, almost like a piecemeal pull.
I don't want to sell bright. First of all, I don't have the bandwidth to look through somebody's phone like that. Okay, I thought the best I could, narrow categories, and that's all I believe that should be produced. I don't want our whole phone. I don't want. That's against the law, period. Okay, so.
Let me find out then if that's the capabilities, and we can take it from there, Your Honor. But I would still say that the bill be presented to the defense and they can pay for it since they want it. Ms. Bridegan shouldn't have to pay for it.
If I may, Mr. Green is former law enforcement. He's worked on forensics, both on the state level and the federal level. He can answer the court's questions regarding capability if the court is willing.
Mr. Green, if you raise your right hand and be sworn in. What? Okay.
Yeah,
Sir, do you solemnly swear or affirm the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am, Your Honor.
All right. What download software do you use?
Yes, ma'am. So our office does two different download capabilities that would be used in a case like this. One through Cellbrite Premium, the other through either, if it's from law enforcement like JSO, would be through Gray Key. Our version of that is called Verikey.
Can you spell it for the record?
Yes, ma'am. Cellbrite is CELLEBRITE. Gray Key is GRAYKEY. Verakey is Verakey. I feel like I'm in a spelling bee. The as you've described, you don't want a complete download of this person's phone. You want what's called an application-specific phone download. Both products, Cellbrite and Verakey or Graykey, have the ability to do application-specific downloads for call log, text messages, the Instagram application.
Can I ask you, hold on just a moment. Let me ask you about the Instagram application. Does that require to hook to the site, or it's whatever might be contained in the phone?
That you are correct. That is only going to be what is existent on the phone. So if that account that you all have referenced of Justice for Jared is not on that phone, we're not going to get data from it. It would have to be pulled either through a court order or search warrant to Meta to pull all of that information, or if we still have access to one of the administrator's accounts, they can log in through a web browser and request that account be archived. That comes down in a format like a zip file that would be processed in forensic software and produced to the court with those messages, direct messages, whatever the court says is responsive. So you do have, for the call logs themselves, yes, the phone at this point is the best piece of evidence. Most likely the carriers do not keep records that long. For Meta, you have, if this account is physically on this phone or Ms. Bridegan has access to a phone that has it, yes, we can get pieces of it, but the best source of evidence for Meta for the page is going to be directly from Meta itself.
Okay. And with both software that you identified, is that keyword search, meaning that it would capture photographs or screenshots of those things, or would there have to be a download of photographs that are related to that?
No, ma'am. If the messages, based on my understanding, something like a text message between Ms. Bridegan and State's Attorney's Office, is that the example that we'd like to use?
My understanding from the pleadings is that some of this, for example, that the court has already reviewed our screenshots. How would that be accomplished?
That was from Instagram.
Messages, and yeah, some of them were.
Okay, so the messages themselves can still, that same application specific download for messages. It will pull if there is an attachment for a picture or video or an audio message. All of those will be pulled within that database. It can then be applied with a date and time filter. It can be keyword searched. Many different ways that we can pull that data and turn it into a subset of data for you to review instead of giving you the 100,000 page Cellbrite PDF.
Okay. Thank you. Do
any
of the parties have any questions?
No, Your Honor. Thank you.
State of Florida, Christina Stifler. Mr. Green, if you were to send a search warrant to Meta, isn't it true that Meta does not have the ability to send back a targeted reply? When Meta receives a search warrant, they return all information for a specific Instagram account.
I don't have the ability to send a search warrant to Meta. However, if JSO or another law enforcement agency was, law enforcement can specify you do not have to ask for any and all data. You can't do keyword searches, but you can apply a date and time.
Okay, but Meta sends back everything. They don't parse out keyword searches, specific accounts, specific individuals, specific users. Whatever is in that account for that time frame, they send back.
I believe that's what I said. They do not give you a keyword responsive list. They give you can apply a date and time filter. But that's the same with the download. You're going to wind up with a subset of data that would then need to be filtered as pursuant to whatever the court allows for their review.
Your Honor, we object on two bases. First, the state withdrew its statutory standing as to Ms. Bridegan. They're not a party to this particular motion litigation. And secondly, this is beyond the scope of Mr. Green's knowledge. He doesn't work for Meta. There's been no foundation laid.
Judge, I'm just sitting here, and I'm by no means am I an expert, but I have had experience with Cellbrite and Meta through the course of my work as a homicide prosecutor. And we had an entire hearing, Ms. Nelson and myself, and Detective Padilla from JSO testified that third-party providers like Meta or Apple are unable to do content-based returns.
Right,
And
but my memory of his testimony was that he would bring in the big cloud of information and he would break it down into what was actually granted by the court. That was my understanding of his testimony. That he would then only give law enforcement what was authorized by the court.
Well, yes, he is law enforcement, but number one, there's no way from Meta to get content-based returns. And even if you request a date-specific time frame from Meta, generally, because they are a corporation and they do not want to waste time and money, they don't parse it out. They will send, as Detective Padilla testified to, they'll send back a wider date range that's even requested. I just want to clarify that. I'm not making an argument.
I don't know how we got on Meta. This subpoena is for the phone. If it's on the phone, okay. If it's not on the phone.
I want the court to understand that from my experience, and just for everyone to know, if we're looking for experts who can do this, when you do a cell bright extraction or forensic imaging of a phone, trying to do a partial extraction and parsing the data in the extraction itself leads to inaccuracies in the data that's being retrieved. The only way to get accurate data and to get the entirety of what the court is ordered and what they are specifically looking for would be to do an entire extraction of the phone and then parse it from there.
That's not lawful.
I understand, but what I'm saying is there's a practical limitation on what everybody's talking about here, which is if you are requesting someone's text messages, say between Kirsten Bridegan and Christina Stifler, they could be stored in a variety of manners in databases on a phone. And if you only go to native message application and try to pull them, you could be missing other ways in which they're stored. You could be missing metadata. They could be duplicated. They could not pull everything entirely. Instagram messages can be stored on phones under the message category within Cellbrite itself. I'm not making any kind of argument. I'm taking no standing. I'm just asking Mr. Green to clarify because my concern is I'm hearing that we're going to recover the data being ordered by doing these content-based extractions. And from my experience and from the testimony of Detective Padilla earlier in this case's litigation, I don't think that that's going to yield accurate results.
That was Ms. Nelson's argument. That was her argument in a nutshell. She said, what's good for the goose is good for the gander. The state of Florida said they get it all, we should get it all. And then everyone shut that down. I've spent an enormous amount of time, researching, looking, and this has to be done in some type of way that the civil people do it. I don't know if they download the whole phone or what they do, but like the only guidance I kind of get, which don't address the issues that are pending before this court, are civil cases that, the judges parse this out in-camera reviews. They don't have the same constitutional rights. That's exactly what Ms. Nelson argued in the very first hearing that we had, and the state of Florida shut it down. They said no, and there have been nothing but objections, and I'm doing my very best to balance all of this. And I do not want her whole phone. I don't think it's lawful. I think I've said it in a number of different ways, but I do believe, based on the information that this court has been given by the defense in this case, that I have to balance Ms. Bridegan's privacy rights against Ms. Gardner's constitutional rights to a fair trial. Discovery, regardless, in the state of Florida is liberal, and it has to lead, and this is a trial case. Therefore, that means that bias, interest, and whatever can be tested by the defense in a number of different ways. And so they have identified this. This is where I'm at, Mr. Green, I don't understand what you mean really by log on to the internet and get whatever from Meta or whatever. I don't understand any of that. The subpoena is for the phone, It has to come from the phone. I'm not expecting, nor would I order, because that's not the proper venue. There is a segment in the case law that says that, is this the proper vehicle, okay, meaning, is this a proper object, Ms. Nelson, okay, that this information should come from. You're not going to use Ms. Bridegan's phone to get access to Meta that you could have sent a subpoena to, okay? It's either on the phone or it's not. That's where I'm at, okay? So I don't understand, that's not going to be ordered by this court, like logging in somewhere and getting that stuff that way. I don't think I did, but.
Judge Kite.
We agree, Your Honor. We're not seeking that, and we
Okay.
don't believe that the court's order authorizes that.
All right, I just want to be clear, because no, that's a no. All right.
Judge Kite, regardless of the vendor you choose, we need to ensure that there is an application-specific download of Instagram and the call logs. That is we're not asking for a full file system download. It's called an application-specific.
Application-specific?
Specific, yes, ma'am.
Okay.
I've been invited to speak on this from the magnet forensics vendors, spoken at conferences on it. We can do a complete download of the phone. I believe you've already said that that is not going to happen. Application specific for things like the phone call logs and the messages and Instagram, whatever you say. There are vendors, including Invista, that have the ability to pull a isolated image of just that specific application.
And so to the extent that the state of Florida is indicating that I've been asked, okay, to narrow the categories, narrow what is recovered from Ms. Bridegan's phone, the state has objected. I've made my ruling, okay? And if it is taken out of context, it's because that is what that's been what's requested by the state. And if there is something in rebuttal that might be existing in her phone, the state of Florida doesn't want to look. And so that's what it is, okay? So, do you want to get in contact with Mulholland or?
I will, Your Honor. I'll talk to him about application specific, talk to him about what can be done in regards to this board specifically.
So I want to make sure that you were heard fully. I don't know if that clarifies. Mr. Clifton, if it's on the phone, okay, and it is substantive, meaning that there's actual information other than phone number, date, time. Like, I don't find any privacy interest in that. So and it's isolated per the numbers that are not public, okay? Those numbers, if they could isolate it that way, the defense gets it initially. They don't need to know who Ms. Bridegan was calling every single day.
And that would be so is there a list of specific numbers that the defense has provided that we are pulling call data?
Yes. Yes.
Your Honor, I apologize. We can't hear if somebody's speaking right now.
He turned it off, sorry. Say that again.
Sorry, Ms. Nelson, I didn't want you to hear me. Obviously, pulling call data logs for 4 years is an enormous amount of information. I think you've already alluded to it. You're just going to get a bunch of calls to other people that are none of their business. If there is a specific phone number, I didn't see it.
I did not put it in
listed
there.
in the subpoena, but if there is, I mean, and that would be obviously A, B, L, B, E, F, I think Detective Johns and.
The prosecutors that were identified.
Yes, so if they have those phone numbers, want to provide them, yes, I will again talk to Mulholland and see about pulling that specific information if that's a possibility, and if we can avoid a full phone dump, Your Honor. And that would be,
That's what I ordered. That goes directly to them.
yes, but it's I don't know what their numbers. I mean, like
I don't either.
Okay.
And I wasn't going to put it in an order that was.
No. But again, I mean, but if they just need to be specific, I guess. I mean, if it's to them, the subpoena was just like, we want the call logs, and I get it, to A, B, and everything else. But I know there was a number of phone numbers that I think A, B used. So
Well,
just for
I don't
clarification
have those
purposes.
numbers. So, Ms. Nelson, will you work with Mr. Clifton and get those phone number list, please?
We will, Your Honor. I will say for the record that the state of Florida knows their own phone numbers. If they could be directed to provide them to Ms. Bridegan and or the defense for production. When we attempted to ask about this in the deposition, we were asked not to ask about it because understandably so, the state of Florida did not want cell phone numbers in the transcript.
I get
So
it. Will
we
you
do
do
not
that,
have all
please?
the information.
Okay, so from the state's perspective, if you could give the phone numbers that are relevant, I obviously did not want to put that in an order, okay? Give them to Mr. Clifton. And
Your Honor,
then,
could
yes.
we require a production deadline for them to produce these phone numbers? Ms. Bridegan also knows the phone numbers. So our concern is it's delay after delay after delay, and we already have a missed court deadline from yesterday. So we're just asking that this information be provided in a timely fashion.
Ms. Nelson, I've got to first figure out who's going to do it before I put a deadline. To me, that's reasonable. I understand. I've got a jury back there waiting. I've got to figure. I need an answer. So if you could get back to me maybe today so that I can make a decision about timelines, please, Mr. Clifton.
Yes, Your Honor.
And is the state going to see if JSO could do it or no? JSO is not going to do it. All right.
I'm not going to ask him.
All right. I want to make sure that whatever is produced to the defense, obviously the rules of discovery still apply. So, Ms. Nelson.
Understood, Your Honor. And I just want to make clear, Your Honor, that we had requested the full image. They objected. They came back and asked for an image, and now they're objecting again to their own proposed solution. So I will also reach out to the proposed vendor. We've proposed a vendor. We will get back to the court today.
Thank you.
And to the extent that we need another status, which we hope we don't need to interrupt the court's schedule in order to effectuate the court's August 11th order. But if we do, we will certainly ask to be put back on calendar this week.
You have priority on this. I designate this as a priority case. I need to get this issue settled so that you all can be prepared for trial. Okay. So I'm not interested in any more delays, but I'm not going to put just a random deadline out there when I don't know the specifics of whether it can actually be accomplished. Okay. So with some more information, I'll try to be reasonable with both sides, understanding that we need to get moving. We need to get past this issue and settle it to the extent that we can settle it in a courtroom of law. Okay.
Thank you, Your Honor.
All right. Thank you.
Thank
All right.
you, Your Honor.
I'll just get, hopefully by the end of the day.
Yes, Your Honor.
Okay. Thank you. All right. This hearing's adjourned. We're going to be in recess briefly to set up for the trial.
Yeah, I'll do it. So you're gonna start.
versus Mario Fernandez-Saldana. If the attorneys will place their appearances on the record, please.
Morning, Your Honor. Christina Stifler and Alan Mizrahi on behalf of the state.
James Hill, Jesse Dreiser, Shannon Day, Ginny Nepstead on behalf of the defense, Mario Fernandez to my left at defense.
Thank you. Good morning.
And as I understand it, Frank Tassoni is on Zoom this morning.
Oh, okay. I don't know where Zoom is anymore, but he can't be on Zoom.
Okay.
We shut the Zoom down. So he might want to participate another way.
Okay. Did you say he was on Zoom?
No,
Earlier, he must have been when there was a Zoom link.
okay.
That's okay. He's not on Zoom.
All right. Let's get the witness back, please. Detective Johns. Just have him come in the courtroom and remain here. I'm going to have him sworn in, okay, before we begin again. Are both sides ready for the jury to be brought in? Is there anything we need to take up?
Oh, yes, Your Honor. The defense, by agreement of the state, has added to what was pre-marked as Exhibit A, put into evidence as 1, and if the court...
Detective Johns, just pause right there one moment.
If the court recalls, 1 was comprised of 1A through 1I, and we've added 1J this morning, which is the suggestion of death in the family law case that was brought up during Mrs. Bridegan's redirect.
Was there any objection?
No, Your Honor.
Okay. All right. So that'll be admitted into evidence. Detective Johns, I'm going to have the jury brought in, and I wanted you to come in. So the moment that they come in, we get them settled. I'm going to have you walk forward. If you can sit there you can sit there if you want, just for a moment. I'm going to bring the jury in, okay? All right, Mr. Holman.
I don't know if I like this. Did you fold this? I'll try it. Just feel it's tight.
Can he just clip it on? This one's on too.
I didn't know we were doing that.
All right, welcome in, members of the jury. Thank you. Everyone may be seated.
It's on now.
Members of the jury, we are in the third day of trial, and just to remind you where we are procedurally, Detective Johns completed his direct examination by the state of Florida. I'm going to ask Detective Johns, he's present here in the courtroom, to come forward. Since there has been a night's recess, I'm going to ask that you take the oath again, and if you could make your way to the witness stand after that.
Detective, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. And just watch your step, okay? All right, Mr. Dreiser, you may cross-examine. Do you need to move that for your? Okay. All right, you may proceed.
Thank you, Your Honor. Good morning, Detective. How are you?
Good morning, sir.
Thanks for being here. You all settled in?
Yes, sir.
Okay. Detective, you would agree that this is by far the biggest case of your career?
Yes, sir.
Okay. This case is not only a big case because of the media attention, it was a long and exhaustive investigation, correct?
Yes, sir.
And I want to ask you a few questions about both. From a media perspective, do you agree that this case did in fact get major media attention?
Yes, sir.
Not only during the course of your investigation early on, there were news reports, correct?
Yes, sir.
Okay. And there were, when people got arrested, the court was recorded, correct?
That's correct.
So not only from what the media kept reporting as you guys got updates in the case, when people got arrested, whatever happened in court was made publicly available, right?
As far as I know.
Sure. Anyone that wanted to watch it on numerous live streams could know exactly what was happening if they so choose to do that, correct?
I mean, as far as I know, I wasn't present for everything, but as far as I know, it was, yes.
Right. And you also know that as your investigation went on, you would sometimes purposely release information, correct?
There were times during the investigation where a decision was made to use an arrest as a tactic, yes.
And there were some times where tactically you did not release information so that the public could not know, correct?
Not necessarily. I'm not sure what you're referring to.
Okay. You sometimes purposefully release information, like the blue truck, and we'll get to that later in my cross-examination. But there were also pieces of information that only law enforcement knew about the investigation that was not publicly available, especially early on in the case, correct?
That's correct.
Okay. Maybe I just didn't ask you a good question. We both agree to that fact, right?
Yes.
Okay. And as part of the exhaustive nature of this investigation, it was 11 months before any arrest was made for this particular case, right?
Yes.
So there's a lot for me to ask you about today. You agree with that, right?
Yes.
Okay. And you were the lead detective in this case?
Yes.
Detective Lamont helped you?
He was my co-lead.
Okay. And as you guys got developments, you never let up, right? You just kept pushing and trying to get more and more evidence to make your case, correct?
I would kind of reject that premise. You follow up on leads, and you either develop new leads and you follow those leads, or information kind of dies out and that lead dies out.
But over the course of 11 months, you were looking for leads. You were looking for new information.
Yes.
I mean, that's what that whole table up there is shell casings from the night of, tires that you later collected, boots that you later collected. I mean, that was what you were doing, right?
That's correct.
Okay. Now, and you've answered most of these questions, but personally, you are only part-time at the Sheriff's Office or the Jax Beach Sheriff's Office now?
Yes.
Okay. You're only putting in about 10 hours a week?
Depends on what's going on. It can vary.
And you are now a financial planner in your own private business, unrelated to law enforcement?
That's correct.
Okay. And because of what you described as some of the background that you have working at banks, they sort of deem you the finance guy at Jax Beach's Sheriff's Office?
I handled most of the financial investigations. That's correct.
Okay. But you agree you don't have any degrees in banking?
I don't think there is a degree in banking per se, but no, I do not have a degree in finance.
Or a business degree of any kind?
No.
Okay. You don't have any degrees in taxation?
I hold a license in taxation, but I don't have a degree now.
You're not a CPA?
I'm not a CPA.
Okay. And in terms of being a financial planner, there are certified financial planners or CFPs. You're not one of those?
I'm not a CFP. I am an enrolled agent, which is a designation that the Treasury issues.
Okay. But nonetheless, without ever having worked a homicide before, because you were on call, this became your case. Is that right?
That's correct.
Okay. I want to get some background, some context, because I think some names have been thrown out in this case. Do you remember saying the name Jeremy Ordway yesterday?
Yes, sir.
Jeremy Ordway became the tenant of Potomac on...
Around the beginning of the year.
Well, it was after January, moving into February, right? And I'll show you the lease later, but I'm trying to give them some context of who Jeremy Ordway is. That was the new tenant of Potomac between January and February of 2022, right?
That's correct.
Okay. And then, of course, we've all heard the name Henry Tenon, and I think you said on your direct examination that Henry Tenon was still living at Potomac after the homicide. Detective Burrell yesterday told us he didn't think he was living there. I'll let the jury make the decision. But my question to you is, Henry Tenon and Jeremy Ordway have a relationship, correct?
Yes, sir.
Okay. It's not like, you know, in a typical situation, you move into a new place, the old tenant can't stay there unless, in fact, you would agree that they are friends.
I would say they're friends.
Right. And it's because Jeremy and Henry Tenon's father, before he passed, they had a relationship, correct?
Yes, sir.
Okay. So in some ways, they were family friends.
It's fair.
They lived on the same street at Potomac.
Correct.
Right. So when Henry Tenon is seen over at Potomac, and I'm going to show you, and we're going to talk a whole lot about it this morning and afternoon, about why those two people are together, it's because they, in fact, are friends, and it's not unusual that Henry Tenon would be at Potomac, correct?
That's correct.
Okay. I'm going to try to go chronologically, but yesterday the jury was left after seeing an interview of Mario Fernandez, and I'm sure you remember that, correct?
Yes, sir.
All right. And I want to ask you a lot of questions about what they heard and what they didn't hear in that interview. Is that fair?
Okay.
When someone goes in for an interview, let's start with a few basic premises. He came in voluntarily.
Yes, sir.
With no hesitation.
That's correct.
He didn't bring a lawyer with him.
No.
He answered your questions.
Yes, sir.
And during that interview of Mr. Fernandez, as a detective, you're gauging whether he's telling the truth or he's lying, correct?
At that point, I'm making a record of what he's saying. I'm not necessarily gauging whether he's telling the truth or not.
In that moment, you're making a record, but certainly as a good detective, you're going to try to find out, was he telling me the truth or was he telling me lies? You have to have done that, right?
Part of what is done when you're doing an interview is you are making a record of what people say, so that later on, if something is said that contradicts that, you have a record of what they said earlier.
That would be a lie.
That's true, yes.
So in a nutshell, I asked you a simple question, which was, you're trying to make a decision after you listen to what they say, you do some detective work, and then you say, was this guy being truthful with me, or was this guy being a liar? That's part of your job, right?
Sometimes, yes.
Yeah. And you're also trying to, and you would agree, people react differently in police interviews, right? There's no right way to react, right?
Correct.
So Mr. Fernandez talked a lot. You would agree with that?
Yes.
Some people could say, well, he talked a lot, so he was nervous. Some people could say, if a person comes in and they don't really expand on their answers, that could be suspicious, right?
Not in itself, no.
Right, because everybody reacts differently to police interviews.
Correct.
So just the way a person acts doesn't tell you one thing or another about their involvement in a crime, correct?
No.
Okay. No, meaning yes, you agree.
I agree with you.
Thank you. Okay, so now let's talk about questions that the state didn't ask you yesterday. Mr. Fernandez told you that there was an issue with AB, sorry, Judge, about purple hair. Do you recall that?
Yes, sir.
And how Mr. Bridegan, Jared Bridegan, went bananas. I don't think that was the word he used, but he went apoplectic. He was pissed off about her wanting to dye her hair purple, correct?
According to what Mr. Fernandez said, yes.
That's exactly right. According to what Mr. Fernandez says. We don't know. But as part of your detective work in this case, you went and spoke to Bishop Curry, correct?
Yes, we did.
And he confirmed that Jared did confront him about purple hair, correct?
I don't remember if it was necessarily about the hair color or something else, but yes, he did go and speak with Bishop Curry.
Yeah, and it was about Bishop Curry giving advice to the Gardner family, and he's a bishop.
Your Honor, the state's going to object. This is all hearsay.
Grounds? Okay. Response?
I'll ask it differently.
All right.
You were able to confirm that what Mr. Fernandez told you about the confrontation between Jared Bridegan and Bishop Curry did in fact happen.
I was able to confirm that there was a confrontation between the two of them.
Thank you. And in fact, that Bishop Curry was pretty taken aback by how aggressive Mr. Bridegan was during that confrontation.
I don't remember his specific language that he used. I believe he was surprised by the interaction.
The aggressive nature of the interaction.
I don't remember him saying aggressive or using that type of language. I just remember him being surprised by it.
He wasn't pleased with Mr. Bridegan coming to his house, was he?
No.
Thank you. You heard Mr. Fernandez tell you that the child reported that during that date night, on the night of the homicide, that Mr. Bridegan took a phone call, correct?
Yes.
Mr. Fernandez wasn't there during that date night, right?
That's correct.
There's no way he could have known that, to tell you that, unless someone told him that, correct?
That's correct.
And you were able to confirm that during that date night, on that day, Mr. Bridegan did in fact take a phone call. It lasted about 20 minutes at the beginning of the date night.
Yes.
So again, what Mr. Fernandez told you checked out to add up to something that actually did happen, right?
Yes.
Okay. There was some school issues brought up by Mr. Fernandez. And Mr. Fernandez told you that the way the school perceived Miss Bridegan and Mr. Bridegan and whether they were friendly, you were able to talk to some of the school teachers in this case, correct?
We talked to one school teacher, yes.
Okay. And I'll represent you. They're going to testify in this trial. But they confirmed that the Bridigans weren't really happy with the school situation, correct?
I don't remember the specifics of the interview. I don't remember them talking about that particular aspect of it.
Okay. Would you agree with me that whatever they tell the jury about how the Bridigans perceived their happiness with the school situation would be the truth?
Your Honor, I'm going to object to speculation.
I'm not asking him to speculate what they're going to say. I'm asking him to speculate, accept that whatever they tell the jury is how they felt.
The court will sustain the objection on other grounds, invading the province.
Okay. So Mr. Fernandez reported to you that Kirsten Bridegan was unhappy with the notification that the school gave out to the public regarding the death of Mr. Bridegan. Do you recall that?
Yes.
You were able to confirm through Mrs. Bridegan that she did in fact contact the school and she was not happy with that.
I don't remember if I confirmed that through her, but it was confirmed.
It was confirmed. So that was also true,
yes.
Correct? Lastly, do you recall one more fact that was confirmed? He told you that Mr. Bridegan's brother had left the church, and there was strife in the Bridegan family about that, right?
I don't know what the particulars were in the strife of the family. I do know that he did, in fact, leave the church.
Right. So let's break that down to what I'm asking you. I'm not asking you about the particulars of the strife. So let me ask a better question. Mr. Fernandez told you in response to issues that were going on that Mr. Bridegan's brother left the church.
Yes, that was a statement that was made by Mr. Fernandez.
And then later you were able to confirm that that was true.
Yes.
So again, as part of the work that you did post the interview, you were able to confirm, for example, he told you the children's therapist was Mercedes McGowan, correct?
Yes.
And that was a big issue that he talked about. You were able to confirm the children's therapist was in fact Mercedes McGowan, correct?
Yes, sir.
And there was issues about whether the Bridigans wanted her going to Mercedes McGowan or whether the Gardner camp wanted her to go to Mercedes McGowan. You confirmed that was a true issue, correct?
Yes, sir.
Okay. So what you're learning from him all sort of panned out, correct?
Everything we've spoken about so far, yes.
And then when someone's giving a police interview, they could just come in, if they wanted to make it seem like they were distancing themselves from a crime. They could say something like, well, there was really no problems between us and the Bridigans, you know, little issue here, a little issue there, but we got along great. And then you would confirm that's not true. Mr. Fernandez didn't do that, did he?
No.
I mean, he told you there were issues. He told you what the issues were, and everything he told you checked out in terms of those issues that he identified, correct?
He was very candid about the issues between them.
Okay. And then, do you recall answering a question yesterday about motive? It's a big issue in this case. The government's alleging that the motive in this case is a child custody issue. You agree with that?
Yes.
Okay, and they asked you, before we even played the interview, at what point in the investigation did you come up with this motive? And you said, well, Mr. Fernandez said that he wanted to do a social investigation so they could get majority time sharing. Do you recall saying that?
Yes.
And that's the snippet of information that you gave the jury before that interview, correct?
Yes, sir.
Okay. But the jury's now heard the entire interview, correct?
Yes, sir.
And it's in evidence, right?
As far as I know.
Okay. But and I don't want to put words in your mouth. I want to use the exact words of what was spoken. So let's see what we can agree on. And any time, if you need to look at the transcript, you let me know, or we can play the video. Okay? Mr. Fernandez told you that there was an issue with the children, AB and LB specifically, and Mercedes McGowan, the therapist, right?
Yes.
And the issue was they thought it was really good for the children, meaning the Gardners, Mario Fernandez and Shanna Gardner, and the Bridigans did not want the children to go to therapy. In a nutshell, that's what he was telling you, correct?
That was the statement made by Mr. Fernandez, yes.
Right. And then, in response, you say, the therapy. Okay? Take my word for you?
Okay.
And then Mr. Fernandez says he wanted it to stop. And he was saying that he never agreed to it and that they had to go and tell the kids, I don't know if he thought that they were in there with the kids. And he goes on to talk about why Mr. Bridegan wanted the therapy to stop. Fair enough?
Yes.
And then you say that's why he wanted it to stop. And then Mr. Fernandez says he wanted it to stop. Then he sent us a thing through his lawyer. We forwarded it to our lawyer. And our lawyer was more or less, is this real? Is this serious? Our lawyer legitimately told us that he ignored it because he didn't think it was serious. And he waited out the time. Then he went back in and got serious and was like, I haven't received a response, and blah, 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 blah. We asked our lawyers, hey, can you respond to this? Because this is getting out of hand now, and it's absolutely ridiculous. Fair enough?
Okay.
Then Mr. Fernandez went on to say, our lawyer was prepared to be like, I hope this goes forward so I could just crush him in court. We were hoping that he was going to push it so that we could file a social investigation against him. I'm going to stop there for a second. Mr. Fernandez was saying, we hope that he was going to push it. Push it was the fact that Mr. Bridegan, he was Mr. Bridegan, you agree with that, correct?
Yes.
That Mr. Bridegan was going to push the issue of taking the children out of therapy. That's what Mr. Fernandez is telling you.
I can only say that, yes, that's what the transcript says, yes.
That's all I'm asking you.
Okay.
What he told you. That's what you're basing your response to this jury yesterday was, we believe the motive, in short, was he wanted to push a social investigation and majority time sharing. You got that from that interview, correct?
That is part of a larger context of things.
Sure.
Yes.
But right now, in the interview, this is the part where we're talking about those two things. Social investigation, correct?
Yes.
And we're about to get to the majority time sharing.
Okay.
So to back it up, he's now telling you what the lawyer was going to do if Mr. Bridegan pushed the issue of taking the kids out of therapy, correct? That's where I left off?
I mean, you're reading a small bit of a long interview.
I'm going to read the whole.
I understand, yes, what you're saying, based upon that part of it, yes, that's accurate.
Okay. So then Mr. Fernandez goes on to say, because up to pretty much this point, the primary goal, because it wasn't amicable and because how they're being with the kids, we were more or less fighting for the kids to have a chance and for Shanna to have majority decision making. Okay, I'm going to stop there. That's different than majority time sharing. That's just decision making for health decisions, correct?
I believe that he wanted them to have control over the children. That's how I perceived his statement.
That's how you perceived it. But
Yes.
the words
Your
are.
Honor, I'm objecting to this line of questioning because it's calling for
Let me
manipulation.
see your sidebar.
Madam Court Reporter?
May proceed.
Thank you. I want to make sure we know exactly where we left off, because I want every word to be considered in this paragraph, because this is the part where you learned about the majority time sharing, correct?
Okay.
So I left off exactly with decision making. So the first thing that Mr. Fernandez said after you were discussing the therapy was that it would be better if maybe she got decision making. That's the word that Mr. Fernandez used, correct?
Right.
Okay. And then in the next sentence, Mr. Fernandez says, if she could have more timeshare on her end, if it was 60-40 or whatever, we could bend it just enough, it'd be great because the kids would be better off. If we could push them into the corner of all the interaction with the kids, we need all to be together so they could just suck it. I don't care if they're suffering because they are uncomfortable, okay? And he was obviously not referring to the children being uncomfortable. He was referring to the Bridigans, correct?
Correct.
And this whole concept that you told the jury yesterday for motive was that Miss Gardner, you believed, and Mr. Fernandez wanted majority time sharing is what you said, correct?
That's what the transcript says.
Right. But 60-40, meaning 10% more time sharing, Detective Johns, correct? That's what Mr. Fernandez said, correct?
In the transcript, yes.
Right. So in the transcript, he's saying if we could just bend it slightly, it would be better off for the children, correct?
That's what the transcript says.
And 60-40 is 2 days a month, correct?
Okay.
Nowhere in that transcript does Mr. Fernandez ever say that they were trying to take away Mr. Bridegan's time sharing, correct?
I think if you look at the total context of the interview,
Yeah.
I believe he was saying that they wanted them to have majority control over the children.
By way of 10% more. I mean, a majority is 51%. I mean, you know from your business background, that's what a majority means, correct?
Yes.
So he says 60-40, 10% more is the majority.
Yes.
We're not speculating because you keep saying, well, that's what Mr. Fernandez said. That's exactly what Mr. Fernandez said. If we could just have 60-40, we could bend it just a little bit, the kids would be better off. That's what he said.
That's what the transcript says.
You keep saying that's what the transcript said. Detective Johns, he is the transcript. You are the transcript. Detective Lamont is the transcript. And Mr. Fernandez is the transcript. That's what the transcript is. It's 3 people that were talking in a room, correct?
Yes.
So when I say that's what Mr. Fernandez said, that's what he said, and then it was transcribed, correct?
That's correct.
Okay. And to be very clear for the record, when I keep saying that's what was transcribed, it's from what Mr. Fernandez said in the interview, not the transcript, because they saw the interview in its entirety yesterday, right?
Correct.
Okay. Now, during your investigation, you never took the time to read the family law docket in this case?
It was read by one of my colleagues.
Okay, but you personally, as the lead detective, never read it?
I have since read it.
Since the last time I asked you, and you told me you hadn't read it, you've now gone back and read it?
I have read the docket, yes.
Okay. Did you actually read the pleadings?
No.
Okay, well, I'm going to represent to you that many of them are in evidence, okay? So I'm going to walk you through that. Is that all right?
Okay.
So let's start with let me go to my notes. Defense Exhibit 1A. When you say that since the time I asked you last, which was only a few months ago, right?
Yes.
So it had been far after Mr. Fernandez was arrested until the time that you read the docket.
That's correct.
Okay. This is the docket that we're talking about, and this is, for the record, Defense Exhibit 1A. Do you agree with me this is the docket?
Looks to be the same.
Okay. And the docket, as you understand it, means all of the pleadings, all of the motions, all the filings are contained within the St. Johns County Family Law Clerk of Court, right?
Yes.
So everything that was done, the jury now has an opportunity to look through because it's in evidence. You agree with that?
As far as I know.
Okay. You're also aware that there was a family group chat that existed between Shanna Gardner, Jared Bridegan, Mario Fernandez, and Kirsten Bridegan.
Yes.
And there were thousands of messages in that family group chat.
There was a lot, and I don't remember the exact number.
And you and your team had an opportunity to look at all of those, correct?
Yes.
And there's nothing that you're aware of in there that had any evidentiary value as to a threat of violence?
That's correct.
Any kind of, let's just not beat around the bush. It was about scheduling for the most part, correct?
But things you would probably expect to find in a family chat.
Yeah. Medical decisions between the children?
Yes.
Pickups and drop-offs?
Yes.
Exchanging medical supplies or school supplies?
Yes.
Okay. And that comprised over years of information that you and your team were able to investigate. And you would agree sometimes there were little snips from one side or the other, right?
Correct.
Okay. But in all of that, there was nothing, as you've already told me today, that you can say, yeah, this went to motive, this went to violence, this went to why we believe Mr. Fernandez is involved in the crime out of the thousands of messages that you read, correct?
That's correct.
Okay. Now I'm going to go back in history and I'm going to show you Defense Exhibit 1B. This is the consent final judgment of dissolution of marriage. Okay? This is, in fact, the initial document that Jared Bridegan and Shanna Gardner agreed to regarding time sharing, or as the state uses, custody in this case. You agree with that?
Yes.
And you know, even with just limited family law knowledge, that a consent final judgment means both parties agreed.
Yes.
They didn't go to court and a judge said, after all this fighting, I give you X, I give you Y. These two parents, for their two children, came to an agreement, and the agreement says, on page 4, page 4. Section 7. No, go down to the parenting plan, sorry. So part of the consent final judgment is also their properties, what they do with their cars, what they do with their houses, correct?
Right.
Okay. And as part of the property, are you aware that Ms. Gardner was ordered to give Jared Bridegan $390,000?
I think it was part of their marital residence, but I don't know the specifics of their divorce.
Right. She got to keep the house. In exchange, she gave him $390,000 in cash.
Right.
Okay. Just want to make sure you're aware of that. Now, where it says time sharing schedule, in section 7, you can go down. It'd just be easier if I have the. Okay. See where it says in section B below, this schedule is intended to be a 50-50 time-sharing schedule.
Yes.
Clear as day, they agreed to 50-50 back in 2015 by agreement of the parties.
Yes.
Okay. Now I want to show you what's been put into evidence as Defense Exhibit 1C. This is called a supplemental petition to modify time sharing and support and other issues. Can you see that?
Yes.
So this is now Ms. Gardner going back to the court and saying, I'd like to change what we agreed to, right?
Correct.
Okay. And now, in the supplemental petition that was filed by Ms. Gardner, if you would go to page 3, paragraph 3. This is the right one. May I approach the hard copies? It's just
Yes.
hard on the computer. This day, there are 2. It's the other one. The one that she filed herself. May I approach the witness?
Yes.
Oh, actually, I'm going to...
Is that still the same exhibit?
It is 1C, and I'm going to try not to be so archaic. I'm going to use some technology.
All right.
Let's see. It takes a second. All right, we got it. All right. Detective, can you see the supplemental petition to modify the parenting responsibilities?
Yes.
Okay, my question was to you. This is Ms. Gardner going in and asking for a change, right?
Correct.
Read for the jury what Ms. Gardner, without the assistance of a lawyer, asked for the judge to do in modifying timeshare.
A more beneficial time sharing schedule for the children has been successfully utilized since June 2016 of 1 week on and 1 week off with a Wednesday date night.
Okay? So she's just asking for a different 50-50 time sharing schedule, correct?
She's asking for a modification to the time sharing agreement.
You have to agree with me that week on, week off is a 50-50 time sharing agreement.
Just reading what the document says.
I'm asking you. If you're with your children for 1 week, and then they're with the other side for another week, and then you're with them for 1 week, and you go a whole year or a whole lifetime, wouldn't you agree with me that's an equal time sharing schedule?
Yes.
Thank you. And in this particular case, and the jury has the ability to look at all this evidence because it's been admitted, it's been marked, and it's in, they can determine what the change was. So without going back, the last one, it was a few days in between, and now she was saying, let's just go a week on and a week off. And you would also agree that she's telling the court that they've already started doing it, and it's been successful since 2016. That's what she says, correct?
Based on the document, yes.
Okay. Wasn't trying to take away any time sharing from Mr. Bridegan.
Not according to this document, no.
Okay. Now, let's go to paragraph 5 of the same document, because now we've asked you about what she asked for. Now let's ask why she asked for it. Can you read paragraph 5 to the jury?
Schedule change has been agreed upon mutually because it allows them to have more stability for the majority of the time, as well as looking forward to a midweek visit with the opposite parent. Having the kids rotate homes every few days was too emotionally upsetting because it was too much instability for them to handle.
Okay. Sounds consistent with what she's asking for, correct?
Yes.
Okay. And did you know, because you've read the docket, that that's exactly what they did? That by agreement, without a judge having to get involved, they agreed to week on, week off with a Wednesday date night. Right?
Okay.
Right?
That's what this says, yes.
Yeah. Well, that's what she asked for, and then they actually came to an agreement to do that. right?
Yes.
Now, in 2019, a few years later, Ms. Gardner files another supplemental petition, which has been marked in evidence as defense 1D. Can you see that?
Yes, sir.
Okay. Take as much time as you need to review it, but would you agree with me, after you've had time, that this supplemental petition doesn't seek to modify time sharing in any way, equal time sharing in any way?
Give me just a moment to read it.
Sure. May I approach the witness?
Yes.
I'll just give you a whole hard copy so you can look at the entire thing.
Thank you.
For the next page.
Okay. What was your question? Sorry.
Would you agree with me that nowhere in that document in 2019 does Ms. Gardner seek to take away any time sharing from Mr. Bridegan?
It just discusses how they'll split up more holidays, and then there's a mention about their schools.
I'm going to ask you all about that.
Okay.
But I thought my question was pretty clear, so let me ask again. Do you agree, after reading that entire document, that nowhere in that document does Ms. Gardner seek to change equal time sharing with Mr. Bridegan?
No.
Thank you. What it does do, so I'll give you a chance to tell the jury whatever you want, is it goes to codify or make Wednesday night the official date night, correct?
Correct.
All right. Now I want to pause on just that point, because in this case, there was a crime that occurred on date night. You agree with me on that?
Yes, sir.
This docket, these pleadings that I'm showing you are all publicly available, correct?
Yes, sir.
So the idea that that's some personal detail that only the Bridigans would know and only the Gardner-Fernandez residents would know is simply not true. It's public information, correct?
The docket is publicly available to my knowledge. Sure. I don't know if there are certain restrictions on documents when they involve minor children or not. I don't know who, I can't say who would and would not know.
I'm not asking. We don't know who went on the docket and read it. I'm just saying it's publicly available, correct?
Yes.
When I asked you about it at your deposition, you said you hadn't read it. You came in today and said you did read it, correct?
That's correct.
You didn't need to get a login or a password or an account, correct?
I couldn't open the actual exhibits. I could only see the docket because I didn't have a registered account.
Okay, but as a public user, you are able to go through and look at it and do it. You just didn't, correct?
I honestly don't know answer the question.
You don't know how to answer the question. You don't know the answer, right?
I don't know.
Okay. So Wednesday she asked for Wednesday night to be the official date night. That's what it does ask in that petition, correct?
Correct.
All right. Then it goes on and it has an issue with school, correct?
Correct.
And then Ms. Gardner acknowledges that the communication between Ms. Gardner and the Bridegan camp, it can be frustrating at times, right?
That's correct.
So she says, we'd like for the court to implement OFW. Do you know what OFW is?
The app, the Wizard app?
That's right, Our Family Wizard. And that's an app that parents can use to better and effectively communicate in a family law case, right?
Correct.
And the other interesting part of her asking for OFW is that it also can be court monitored, correct?
As far as my understanding.
Right, so that it keeps people honest. If once it's on OFW, it's recorded, and if the court is so inclined to look, they can. That's one of the tools that OFW offers and why courts utilize it, correct?
As far as my limited understanding, yes.
Sure. And of course, in this case, Ms. Gardner is saying, let's give OFW a try. That's what she's asking for in the supplemental petition.
That's correct.
Right. Then the next issue that Ms. Gardner brings up is now an issue between the new step-parents that are involved. Because in 2019, Mr. Fernandez is now involved with the children, correct?
Yes.
Kirsten Bridegan is now involved with the children, correct?
Yes.
So read for the jury what Mrs. Gardner petitions the court in regards to the parties, new step-parents.
Are you talking about the number 10 on the screen there?
Please read paragraph 10.
The father is currently insisting that the mother's new husband may not exercise overnight time sharing with the minor children when the mother is away. He is additionally creating problems with the mother's new husband being involved on a more general basis with the minor children. However, he insists that his own new wife should be fully involved in the children's lives. The father's new wife is a positive influence in the children's lives, as is the mother's new husband. Both new spouses have strong and positive relationships with the minor children. This paragraph should not be construed as a personal attack on either step-parent.
She went out of her way to make sure that even with what they wrote in that paragraph, that no one would perceive it as a personal attack, right?
That's what it says, yes.
Ms. Gardner went out of her way to say that Ms. Bridegan is a positive influence in the children's lives, correct?
According to this document, yes.
That's all I'm asking you about, what's in the
Yes.
That's all it says, is that she's a positive influence in their lives, correct?
Yes.
And she's saying that Mr. Fernandez is also a positive influence in their life. That's what the document says, correct?
Yes.
Right? And she's asking for the court to clarify their old parenting agreements that don't address step-parents, correct?
That's correct.
She didn't do this outside of court in a self-help mechanism. She went to the judge, she described what the issue was, and she asked for court intervention, correct?
That's correct.
Without personally attacking anybody, right?
According to the document, that's correct.
And without taking away a single second of time sharing from Mr. Bridegan, correct?
According to the document, yes.
Well, you keep saying according to the document. So let me ask you, what document are you going to tell me exists that's contrary to what I'm asking you? The whole docket's in evidence. Show me the court document that says that she took away time sharing from Mr. Bridegan.
I'm not aware of a document that says that.
Because it doesn't exist, right? That's why I'm walking you through this, to show that the documents that do exist show time and time again that they had an equal time sharing schedule that no one interfered with, correct?
Correct.
It's been alleged in this case that this was one of just the most toxic family law cases. So that's why I'm walking you through this. So now I'm going to show you what's been marked and put in defense exhibit later in time as 1E. Can you see that?
Yes.
It's a motion for school determination and request for expedited hearing, meaning school's coming up, we got to figure out what school they're going to, can we get a quick hearing? You agree that's what it says?
Yes.
Okay, now I'm going to show you what's been marked as 1G. I'm sorry, 1F for the record. Consent order regarding school choice. Without going to court, the parties immediately came to an agreement and picked a school. Correct, Detective?
Yes.
By way of agreement, they just said, we can do this on our own. This is what we came up with. That's what the consent order says.
Yes.
Now I'm going to show you what's been marked as Defense Exhibit 1G. This is the mother's motion for declaratory relief. If you want to take a moment to read it, I can give you the hard copy. This is regarding an issue regarding the breathing machine for LB, correct?
That's correct.
Simple issue. They were trying to figure out who should keep the breathing machine, correct?
That's correct.
And the jury's heard somewhat, but LB had a breathing issue and some medical issues where he could only live in certain parts of the country that were near to sea level, right?
Yes, sir.
Okay. Now I'm going to show you Exhibit 1H. Mr. Bridegan responds to the motion, correct?
Yes, sir.
Okay. Now I'm going to that was 1G for the record. Sorry, Your Honor. And now I'm going to show you what's 1H. Again, no court intervention. The parties came to an agreement and a consent order on that exact issue was entered into evidence, or was filed, correct?
Correct.
All right. On the family. So to wrap it up, it's all in evidence for the jury to see, but when there were issues leading all the way up to the time of the homicide, they went to court and they agreed, correct? By way of consent.
According to these documents, yes.
Are you aware, has anybody reported to you that there was some nasty trial in this case where witnesses were called and mudslinging occurred that I'm just not asking you about?
No, sir.
May I approach?
Yes.
I'm going to collect a document and drop off a document.
Okay. You may throughout, Mr.
Thank you, Your Honor.
Okay.
That sticker is for the clerk's office. Okay, thanks. Did you get a second to look at it?
Yes, sir.
I keep forgetting because I'm a dinosaur, but there's better technology where everybody can look at it together. I'm showing the witness what's been marked as 1J and entered into evidence. Detective, this is a suggestion of death.
Yes, sir.
This was not filed by Ms. Gardner herself. This was filed by her attorney, correct?
Correct.
And you know that because if you go to the second page, it says respectfully submitted Denry Mason, correct?
Yes.
And you know that was her family law lawyer.
Yes.
And it has two paragraphs. One, that Mr. Bridegan died on February 16, 2022. That's true?
Yes.
And don't you think after reviewing the entire docket, and you may not know this, that that's required, that when a party in a family law case dies with minor children, that the court needs to be made aware? Does that shock you?
No.
Okay. And 2, there is not currently any pending issues before the court and no hearings are scheduled. That was true, correct?
Correct.
Because if you look on the docket sheet, and I'll be glad to show it to you, 1A, the last open pending issue was 4 months prior in October of 2021.
Yes, sir.
Correct?
Yes.
And the case was closed.
Yes.
I'm going to switch gears from the family law case, okay? To give the jury a little bit of background, Mr. Fernandez and Ms. Gardner, they lived in Jacks Beach at the Marsh Inlet address, right?
Yes, sir.
Mr. Fernandez owned a few rental properties in town, correct?
Yes, sir.
One of them was the Potomac address.
That's correct.
And at a certain point in time, Mr. Tenen lived at the Potomac address, and then like we talked about, and I'll show you some documents in a minute, Mr. Ordway moved in and became the official tenant of the Potomac address, correct?
Yes, sir.
But January 5th of 2022, the year of the homicide, Mr. Tenen was in fact the tenant of Potomac.
Yes.
In this case, there was some FBI analysis done on cellular devices, correct?
That's correct.
Okay. And in this case, Agent Blythe, who I expect the jury will hear from during the course of this trial, he was not a detective in this case, correct?
No.
He was solely utilized by law enforcement to do cast analysis or cell phone analysis of location of devices, correct?
Yes.
He didn't subpoena any documents?
No.
You and your team took care of that?
Yes.
So whatever documents he used from T-Mobile or Google or whatever the case may be, that's information that your investigative team subpoenaed, gathered, got by way of warrant, however, and then you would provide that to Agent Blythe, correct?
Yes, sir.
If there was a particular address in this case, that's not something Agent Blythe would be aware of. He would rely on the investigators and the detectives, such as yourself, to give him that information, correct?
Correct.
So if there was a location of interest, not something Agent Blythe would have any idea about, he would rely on you to give him the information, and then he would map it, correct?
Yes, sir.
And I'll allow him and the government to go through all of his analysis, but in fact, he did mapping in this case.
Yes, sir.
And there are certain days of interest that the information you provided him, he mapped for you at your request, correct?
Yes.
All right. So let's start with January 5th, okay? On January 5th, yes, and this for the record is, I'm just going to go back. I'm sorry, Detective. Before we go into January 5th, I forgot a question that I need to ask you, okay? Can I just take you back to the interview of Mr. Fernandez?
Yes, sir.
All right. And I'm sorry to jump around. I made this mistake. Don't hold it against me, please. Do you recall in the interview that Mr. Fernandez kept saying, I don't know why he got out of the car?
Yes, sir.
And let's talk about those interviews again. It is not uncommon that in law enforcement, a person can give a detail during an interview where they shouldn't know that detail, correct? Let me ask a better question. Sometimes there are details about a crime scene that only people that were at the crime scene are aware of. Do you agree with that?
Yes.
Okay. And sometimes when people give interviews, they oust themselves by accident, revealing a detail that only somebody at the crime scene or law enforcement would know, correct?
That's correct.
Okay. And when Mr. Fernandez was interviewed, it was a couple weeks after the homicide?
Yes.
An important detail that this jury should know is that you had not released to the media that the tire was in the road. That was not public information.
I do know it was released eventually. I don't remember the exact timeline that it was released.
Okay. I'm not concerned about when it was released.
Okay.
What I'm concerned about is that at the time Mr. Fernandez was interviewed, you know that it had not been released at that point.
Correct.
That's what I'm asking you. So when he's saying, I don't know why he would get out of the car, he doesn't know that there was a tire in the road, correct?
I don't know I can't testify to what he knows or doesn't know.
He doesn't say anything about a tire, correct?
Not during the interview, no.
Right. He says something about maybe he knew the person in front of him, or maybe I just can't imagine why he didn't run him over. He gives all sorts of, hypotheticals as to what happened, but he never mentions that there's a blockade or a tire or anything obstructing the roadway. Never even suggests that at all, correct?
That's correct.
Okay. And I'm so sorry. I meant to ask you that question, and I forgot. May I have a moment, Your Honor?
Yes. Mr. Dreiser, can we take a break shortly?
It was public knowledge that Mr. Bridegan was killed outside of his vehicle, correct? That had been released.
I don't dispute that. I just don't know exactly what was and wasn't released.
To ask it real simple, there's not a single fact that Mr. Fernandez said to you regarding his hypotheticals of what could have happened that gave you any concern that he had more information than he should about the crime that occurred?
At the time of the interview, no.
Right. Good time for a break, Your Honor.
Okay. I didn't want to interrupt you, but so members of the jury, we're going to pause at this time frame. We're going to take 15 minutes, so that would be about 10 minutes after 11, okay? Enjoy your mid-morning recess. Leave your notepads on your chair. Thank you. Okay, welcome in, everyone. Everyone may be seated. If you could get Detective Johns again.
Go ahead and publish that map. Make it as big as possible. Okay.
All right, Detective Johns, just make yourself comfortable again, okay? Mr. Dreiser, you may proceed.
Thank you.
Thank you.
All right. So, Detective Johns, we're back at the January 5th date, but just to recap, you assisted providing information to the FBI so that they could map slides, correct?
Yes, sir.
Some of the things that you would give were phone numbers, like Mr. Fernandez's, correct?
Correct.
To the FBI. So let's look at the top of, and can you see what's been marked and entered into evidence as State's Exhibit 182?
Yes.
And 182 is a composite of all of the work that the FBI, Agent Blythe, did in this work?
That's correct.
In this case, excuse me, right?
I think it's a slide as part of his overall deck, yes.
Yes. There's a deck of slides. That's the work that Agent Blythe completed in this case.
Correct.
I'm now showing you one of those slides.
Yes.
They're all in evidence, right?
Yes.
Okay. And at the top right corner, it says page 8. So that's an easy way to identify what slide we're looking at, right?
Yes, sir.
Okay. And then at the top, it says 904-566-2633. That was Mario Fernandez's phone number at the time, correct?
Yes.
And then this is January 5th of 2022, so the month preceding the homicide. And it's between 10:56 and 11:51. That's what the slide is suggesting the data shows on page 8 of State's Exhibit 182. Is that fair?
Yes.
And that's information, once again, that you provided the FBI so they could make these for us.
That's correct.
Right? So, in fact, in the legend in the top right corner, it shows, and just, I don't know if the state asked you this, in your homicide training that you said you had, and you said admittedly it was mostly after the homicide, but you do have some CAS training.
I took like an introductory CAS course, yes.
Okay, and these are CAS slides, so you have some familiarity with what we're talking about.
Some, yes.
Okay, and I'm not going to ask you your opinion as to how these slides were made. We all can agree that is what Agent Blythe did in this case, not you.
That's correct.
But in the top right-hand corner, that is, again, where you are involved because you gave the information. And there's a little yellow, I don't know what you call it, marking, and you have the location of interest. See
Yes,
that?
sir. Yes.
And that's the Pablo Hamlet area.
That's correct.
And the jury heard a lot about Pablo Hamlet yesterday. That's the area where the Pablo Hamlet retirement community is and those other apartment complexes where the truck was seen a few times before and after the homicide.
Yes, sir.
Okay. And then you have the Fernandez residence, and that's in the legend in the top right-hand corner, right?
Yes, sir.
And 1511 Marshall is the Fernandez residence, right?
That's correct.
Okay. Fair to say that in this slide, it's just showing that Mario Fernandez was in the area of Jack's Beach at that time.
I'll let Agent Blythe speak to the slides, to interpret the slides.
Okay, so you don't feel comfortable, even with your limited knowledge and this being an evidence saying, yeah, it's Mario Fernandez's phone number and he's in Jack's Beach. You can't determine that?
I'm not saying I can't determine it. I'm saying Agent Blythe is an expert in this. He created these slides. I'll let him speak to them.
Well, I'm asking you to speak to it. So can you tell us, as the lead detective in this case, who furnished all of the information to make these slides, that Mario Fernandez, according to this slide, is in the area of his home between 10:56 and 11:51.
Yes, it would seem that he is utilizing, during the phone calls that are made on the slide, he's utilizing the green dotted cell towers.
And those cell towers are in the area of his home.
Yes.
You don't know where he is in Jax Beach, you just know he's home.
I can only tell you what the slide
you just
says.
know he's in the area of his home.
I can tell you that his cellular device is utilizing the towers that are indicated on the slide.
Okay. You could go to the next slide. On the other hand, you also provided the FBI so they could make maps. Henry Tenon's information, correct?
That's correct.
And then they were able to use geolocation to determine where Henry Tenon's devices went during the course of your investigation, correct?
Yes, sir.
And January 5th is one of the days in which you anticipate that Agent Blythe is going to testify about because you provided him information on those days, correct?
Yes, sir.
So without going into what the evidence shows specifically, you agree that on January 5th, not early in the afternoon in the first slide I showed you, later in the afternoon, Mr. Tenon's devices appear to travel from the Potomac address to Jax Beach.
Yes, sir.
That you're comfortable saying?
Yes.
Okay. On this particular slide, page 9, you've added the crime scene, right?
Yes, sir.
You have no information that Henry Tenon's device went to the crime scene on January 5th, correct?
Based upon the slide and the data points that are here, it doesn't show that.
Okay, can you go to the next slide, please? I'm sorry, the next page number. This is a more zoomed in location of where the Fernandez residence, the location of interest is, correct?
Yes, sir.
All of this is Henry Tenon's device, correct?
That's correct.
Looking at page 9 or 10, you have no information as to where Mario Fernandez is on January 5th.
Not on the slide, no.
Okay. And I'll give you an opportunity to look at all of the slides from January 5th. But in all of the information that you provided the FBI on January 5th, you have no information as to where Mario Fernandez is on that date, correct?
There are no data points available, correct?
There are no data points available. Therefore, you don't know where Mario Fernandez was on January 5th, correct?
There is no physical evidence to say where he was at.
Okay. Do you agree that's the same thing as saying you don't know where he was at?
Correct.
Could be at his house?
Correct.
Could be anywhere else, you have no idea.
Correct.
All right. So now, on January 5th, Henry Tenon's device does travel into the area of the Fernandez residence and the Pablo Hamlet residence, correct?
It travels to the data points that are here, which is, looks like down 15th onto Marsh Inlet and then down to the Cradle Creek area and then a little bit down Fairway.
Okay. Because of what you said about your comfortability, I'll save my cross-examination for Agent Blythe as to where exactly it went. But in this slide, no information about Mario Fernandez.
That's correct.
Okay. And I'm sorry, I'm going to stop saying slide. Page 10, can you go to page 11? This is more time period.
Yes.
Mr. Tenon's devices, correct?
That's correct.
No idea where Mr. Fernandez is or his devices are.
There's no information on the slide now.
So you did not provide that to the FBI, and you don't know.
Correct.
Next page. More zoomed in. Evidence that Mr. Tenon's devices were in the area of Jax Beach on January 5th, right?
That's correct.
No information as to where Mr. Fernandez is that day.
No.
There's not a single piece of information that you can provide this jury on January 5th that you know that Mario Fernandez was with Mr. Tenon.
There's no physical evidence available for that now.
There is no evidence of that.
Correct.
And on January 5th, Henry Tenon was still the tenant of Mr. Fernandez, correct?
Yes.
So if the argument were to be made that he has no reason to be in that area, his landlord lives in that area, correct?
That's correct.
It's the 5th of the month, correct?
Correct.
It's the last month that Mr. Tenon was a tenant of Mr. Fernandez, correct?
I believe there's some information. I don't remember he was the end of December when he stopped being his tenant, or was it the beginning of January?
So you don't know as you're the lead. I mean, I'm asking you. Jeremy Ordway became the tenant of Potomac come February 1st, correct?
Yes.
Okay. So it's the last month that Henry Tenon was at the home prior to Jeremy Ordway, correct?
That's correct. I mean, I don't know exactly when Mr. Tenon's lease ended, is what I'm saying.
Understood. You did learn during this investigation that Mr. Tenon was having a hard time keeping up with his rent, correct?
Yes.
Okay. And that Mr. Fernandez was trying to work with him the best that he could, correct?
I believe there was some conversations that he was trying to work with him, yes.
And he was trying to get whatever money he could until he just could no longer keep him there because he just couldn't keep up with his rent payments, correct?
I assumed that that was the case, but I mean, I don't know exactly when the lease ended, is all I'm saying.
I gave you that. We don't know exactly when it ended. We just know when the new one started. But at this point in time, it's January 5th, and a person who, at that time or just prior to, who you just told the jury was having a hard time keeping up with his rent, is briefly in the area of his landlord's house for about 30 seconds on January 5th, correct?
That's correct.
And that's all the information that you have.
Based on this, yes.
Okay. I'm going to show you what's been marked and put into evidence as Defense Exhibit 19. Can you make that bigger? Okay, scroll down a little bit. All right. I'll zoom in. You and I may be more familiar than the jury with the evidence. You've seen this before?
Yes.
Okay. And this is a rental agreement between Jerry Ordway and Jeremy Ordway for the Potomac address, correct?
Yes.
And this is the and it's signed, if you scroll to the bottom. It's signed by Mr. Fernandez, correct?
That's correct.
And it's signed by Jerry Ordway and Jeremy Ordway?
Correct.
And it's 1/27/22, right before the 1st of February.
Yes, sir.
And you were able to find that lease at Potomac when you guys did the search at Potomac?
Yes, sir, that's correct.
And you were able to confirm with Jeremy Ordway that he lived there and he was the tenant?
That's correct.
Okay, so that all adds up.
Yes.
And through your investigation, you learned that Jeremy Ordway did, in fact, pay rent to Mr. Fernandez.
Yes.
You saw checks where Jeremy Ordway wrote his rent payment to Mr. Fernandez?
Yes.
You confirmed that people that would live at Potomac would also do some work to improve the property, and sometimes that would subsidize their rent, correct?
That's a vague question. I don't understand.
Okay. Mr. Ordway was confirmed that he did some work at Potomac while he was living there.
Yes.
Okay. You learned that Mr. Tenon did work at Potomac while he was living there.
It was stated that he did some work, yes.
Okay. No dispute that Jeremy Ordway took over and continued to pay Mr. Fernandez for living at 5239 Potomac Avenue.
No.
We talked a little bit about Mr. Tenon and his financial situation around the time of the homicide. I think you said he was having trouble keeping up with the rent.
I think you said that, but.
And you agreed.
Yes.
Okay. And he was not in a good financial situation at that time of his life, correct?
That's correct.
And you know that because you've seen his bank accounts and they don't have a ton of money in them, right?
That's correct.
And you know that because you have pawn records that you found where at that time Mr. Tenon was pawning things, correct?
I don't think I ever saw pawn records.
Okay, let me show you what's been marked as Defense Exhibit 21, an Advance America pawn receipt from 2/26/2022. Oh, I'm sorry. I said the wrong thing. Pawn receipts. Advance America is he went on 2/26/2022 in Defense Exhibit 21, and he got a
cash advance.
A cash advance.
Yes, sir.
Okay. So approximately 15 days or so after the homicide, Mr. Tenon went and got a cash advance.
That's correct.
And as a detective, that would tell you that he needed money, correct?
That's correct.
Let's talk a little bit about John Biggerstaff, okay?
Okay.
John Biggerstaff is a longtime friend of Mr. Fernandez, correct?
That's correct.
John Biggerstaff's daughter went to high school with Mr. Fernandez, correct?
Yes.
And that's how he met John Biggerstaff decades ago, correct?
As I assume, or what I've heard, yes.
No reason to dispute that fact, right?
No.
Okay. And over the years, Mr. Fernandez and Mr. Biggerstaff did work together, correct?
Yes.
Mr. Biggerstaff had a little side business called 904 Handyman,
Yes.
and Mr. Fernandez had rental properties, correct?
Yes.
And there's no dispute, because I'm going to show you what's been marked into evidence here in a little bit, that you know that John Biggerstaff went to Potomac and did work. He did tile work there, correct?
Yes.
And you know that because you saw messages between them about doing tile work, and then we'll get into poll camera footage. You actually saw him show up and do the tile work.
Right.
All right. So no dispute that John Biggerstaff did work for Mario Fernandez.
No.
You also know that Mario Fernandez would hang out with John Biggerstaff from time to time, correct?
Yes.
They certainly weren't best friends, but they'd have a beer together every once in a while, right?
That's correct.
You also know in this case that John Biggerstaff's son, Juan Biggerstaff, around the time of the homicide, was getting married here in town, correct?
Yes.
And you know that Mr. Fernandez helped set up tables and chairs by using his pickup truck and delivered it to the wedding venue, correct?
That's correct.
You were able to confirm that with receipts from the table and rental company, right?
Yes, sir.
You were able to confirm that with some cellular data that Mr. Fernandez went after the homicide to a storage unit, and you were able to confirm that by people who saw him drop off tables and chairs.
That's correct.
Okay. So no dispute that they knew each other and they did things for one another like delivering tables and chairs, right?
Correct.
Like tile work, correct?
Correct.
On January 25th, you have reason to believe with cell phone data, and I'll save it all for Agent Blythe, that Mr. Fernandez went over to Mr. Biggerstaff's house on that date, correct?
That's correct.
You know, because we just talked about all the things, that that's not unusual that Mr. Fernandez would go to Mr. Biggerstaff's house, correct?
I mean, I have a limited period of time that we reviewed, but it didn't seem unusual.
Right, didn't seem unusual. And while he was there, you have no idea what he was doing at John Biggerstaff's house, correct?
That's correct.
You don't know if they were having beers. You don't know if they were involved. And let's just let's just get it out in the open. Mr. Biggerstaff was a swinger, correct?
Yes, sir.
And his wife was a swinger, correct?
I never spoke to his wife about it.
Sure enough, okay. But Mr. Biggerstaff wanted to film people having sex with his wife, correct? They were into that.
I don't know.
You don't know?
I know on one occasion he did film his wife having sex, but I don't know. I can't say what he was into specifically.
Are you sure it was only one occasion, Detective?
That I'm aware of.
Would you like to see, not the video, I don't think that's necessarily important, that on other dates, there are other men, not Mr. Fernandez, who had sexual relationships with Mr. Biggerstaff's wife. You dispute that?
No.
Okay. And you don't dispute that Mr. Biggerstaff participated in that, correct?
No.
It wasn't that Ms. Biggerstaff was cheating on Mr. Biggerstaff. That was a lifestyle that they chose to live, correct?
According to Mr. Biggerstaff, that's correct.
And the videos that will spare the jury from watching that we found in this case and we saw with our own eyes, correct?
That's correct.
Because you got Mr. Biggerstaff's cell phone downloads, and when you got them, you saw the videos, right?
I did not personally go through every single video, but there were a lot of explicit videos on his phone.
You're not disputing what I'm saying to you, are you?
I'm not.
Okay, so just so we're clear, I'm not making this up. This is what was on the phone, right?
That's correct.
And on that particular day, the day I've been asking you about, January 25th, you've already told me you don't know what Mr. Fernandez was doing over at that house, correct?
That's correct.
Other times, you had seen a video where Mr. Fernandez did have sex with John Biggerstaff's wife, correct?
That's correct.
But on that day, there is no video, but you just don't know, right?
Correct.
Beers in the garage, sex with his wife, helping him build a tool bench in his garage, or the tens of thousands of other things they could be doing together. You just don't know, correct?
I don't know.
But what you certainly have no evidence of is that Mr. Biggerstaff gave Mr. Fernandez a 10-millimeter firearm, do you?
There is no physical evidence of that now.
Okay. When you say no physical evidence, there is no evidence of that, correct?
There is no physical evidence of that.
Okay. So let's talk about John Biggerstaff and this 10-millimeter. Yesterday, I thought I heard you say that it was a very rare weapon. Is that what I heard you say?
Yes, sir.
You also told me in one time that we've previously spoke that it was no golden goose.
That's correct.
Okay. You also said yesterday it's no unicorn.
That's correct.
There are tens of thousands of 10-millimeter firearms out in the universe, correct?
It's probably accurate. I don't know exactly how many have been manufactured.
And let's talk about John Biggerstaff's first, and then let's talk about what your investigation revealed as to other 10-millimeters, all right? Back in 2016, John Biggerstaff bought a 10-millimeter firearm, correct?
That's correct.
All right. So just a little time perspective here. The homicide's in 2022.
Correct.
We're going all the way back to 2016, right?
Right.
I'm going to show you what's been marked in evidence as State's Exhibit 191. Can you publish? All right. Can you see that?
Yes, sir.
And this is a firearms tracing document that the ATF did in the assistance of this case, correct?
Yes, sir.
And this is how we know that John Biggerstaff owned a 10-millimeter back in 2016, because he bought one, right?
Yes, sir.
He bought it legally, right?
Yes, sir.
There's paperwork on it, right?
Yes.
And we know that he had a Glock 40 Gen 4. That's the manufacturer and the model. That's in the top right-hand corner, correct?
That's correct.
And we also know that the serial number of that firearm is BBG L770, correct?
Yes, sir.
Okay. So that's the basis of how we all know that 6 years prior to the homicide, John Biggerstaff owned a 10-millimeter, right?
Yes, sir.
So then, you know that John Biggerstaff got himself in trouble right around the same time that he bought that gun, correct?
Correct.
He got arrested federally after the purchase of that gun in 2016, correct?
Yes.
And as a part of his arrest, a federal magistrate ordered Mr. Biggerstaff to forfeit and remove from his possession all of his firearms, correct?
Yes.
I'm going to show you what's been marked as Defense Exhibit 5. Okay. Can you see Defense Exhibit 5 on the screen, Detective Johns?
Yes, sir.
This is, in fact, an order setting conditions of release.
That's correct.
You go all the way to the bottom? While I'm scrolling down, you can see refrain from possessing a firearm, destructive device, or other dangerous weapons. Defendant shall immediately remove all firearms he currently owns from the residence, correct?
Correct.
And this was signed by a federal magistrate here in the Middle District and a building about a block from where we are right now, Monty Richardson, correct?
Correct.
You agree with me that federal magistrates take their orders pretty seriously, correct?
Yes.
And they ordered him, as I just read to you, to get rid of all of his firearms, correct?
That's correct.
So in order for him to do that, you would agree they just don't take your word for it. They make you fill out a firearms affidavit where you mark all of your firearms, their serial numbers, their information, so that you show and prove that you no longer have them in your possession, correct?
That's correct.
All right. So now I'm going to show you what's been marked, and that was signed, for the record, October 28th of 2016.
Correct.
And he hadn't been convicted of a felony at this point. This is just when he got arrested. This was his conditions of release order.
Correct.
Just make sure that's clear. Okay. This document's a little harder to see. Blow it up. You know, State's Exhibit 190 is, in fact, the federal firearms affidavit that John Biggerstaff filled out in 2016, correct?
I believe this list was completed by his son, but yes.
Right, because, of course, he can't be in possession of firearms once Magistrate Richardson says you can't be around your firearms. So by the very nature of filling out a firearms affidavit, you have to have some help, right?
Yes.
Because if you sat there and did it yourself, you'd immediately be in violation of the order, right?
That's correct.
And you came to learn that law enforcement was present when they did this, someone from federal probation.
I believe so. I don't know that for sure, but...
Of course, you weren't there, but that's what you learned, is that his son, Juan Biggerstaff, was there with someone from federal probation. Right?
That's what was told to us, yes.
Okay. And he had he had 20 firearms, right?
Yes.
So let's just be clear what this shows and what it doesn't show. We know he bought a 10-millimeter firearm in 2016, previous to this federal firearms affidavit being filled out. Do you agree with that?
Yes.
So if we are trying to look to see if we had a unaccounted for weapon, this would be a good spot to find out, right? Let me ask a better question. We got to look to see if a known firearm that we know he owned is included on this federal firearms affidavit. That's an important detail, correct?
Yes.
Okay, so let's zoom in to line 7. Do you see line 7?
Yes, I do.
And you've seen this document before. This isn't the first time. It says Glock, right?
Correct.
It says 40 Gen 4, correct?
Correct.
So just let's go back in time, just one exhibit before. It was a Glock, right?
That's correct.
It was a 40 Gen 4, correct?
That's right.
And then I read to you the serial number, and I read to you BBGL 773, I believe.
That's correct.
0, excuse me. The exact same firearm that Mr. Biggerstaff purchased in 2016 is documented as forfeited on his firearms affidavit, correct?
That's correct.
Later, in 2017, John Biggerstaff was in fact convicted of a felony, correct?
Yes.
John Biggerstaff, since 2017, has been and is a convicted felon, correct?
Correct.
A convicted felon under federal law cannot own or possess a firearm, correct?
That's correct.
Cannot own or possess ammunition, correct?
That's correct.
Under Florida state law, a convicted felon cannot own a firearm, correct?
That's correct.
They cannot own or possess any ammunition, correct?
Correct.
Okay. If you do, felonies, correct?
That's correct.
All right. You have no information that since 2016 that John Biggerstaff has ever been in possession of a firearm, correct?
I don't know that that's necessarily true. There's some information that he might have taken back his weapons.
Do you have any pictures of John Biggerstaff with his firearms?
No.
Do you have any surveillance of John Biggerstaff with any of his firearms?
No, I do not.
Has John Biggerstaff ever been arrested for felon in possession of a firearm since he has been a convicted felon?
No, sir.
In federal court?
No.
In state court?
No.
The firearm in this case, and the jury will hear all about, and they're going to hear from John Biggerstaff, and they're going to hear the trajectory of that firearm. But I'm asking you, during the course of your investigation, you didn't find a 10-millimeter firearm?
No, sir, we did not.
Okay. You interviewed John Biggerstaff to find out if he could tell you where that 10-millimeter firearm is, correct?
That's correct.
And to this day, there is no murder weapon in this case.
It has never been recovered.
So all these shell casings and all these projectiles and all the things that are sitting right here in front of the jury have never been matched to a particular firearm.
That's correct.
And to be very clear, they have not been matched to a Glock Gen 4 with the serial number BBGL770.
That's correct.
There has not been one single person to report to you that John Biggerstaff has had his firearms since 2017.
No, no one has directly said that.
And you've interviewed as many people as you could to try to get someone to tell you that, correct?
Yes.
There's no social media posts where John Biggerstaff is seen with a firearm, correct?
That's correct.
Now let's talk more generally about these 10-millimeter, not unicorns, not golden goose weapons, okay? You did try in an investigative effort to see what you could find in Jacksonville regarding 10-millimeter weapons, correct?
Yes, sir.
And about a month after the homicide, for whatever reason, you chose to go, or you and your investigative team, to Beach's Pawn. You know what I'm talking about?
Yes, sir.
That's just one pawn shop out of, I don't know, probably 100 or more pawn shops in town?
Yes, sir.
Okay. Just one that you picked?
We just, it's happened to be the only licensed firearms dealer in our jurisdiction. Due to the nature of pawn shops, we have a relationship with the owner. So we went to the pawn shop in Jacks Beach that we knew that we could go to the owner and asked for his assistance.
And he assisted you?
Yes, he did.
Okay. I'm going to show you what's been marked and put into evidence as Defense Exhibit 55. I don't think it matters to show one for the moment. when you went to the pawn shop, you were able to get some paperwork regarding 10mm firearms that were sold by Beach's Pawn, correct?
That's correct.
And at the only pawn shop that you went to, in your jurisdiction, 6 10mm firearms had been sold when you went on March 15th of 2022. That's the evidence that you were provided, correct?
Yes, sir.
Okay. And out of the 6 transactions that are in evidence, every single one of them, and do you see the blacked out portions, Detective Johns?
Yes, sir.
I'm going to represent to you that we redacted their names, and do you agree that's just where someone who purchased a 10mm did so at Beach's Pawn?
Yes, sir.
And do you agree just to protect their privacy, that's why we did that?
That's correct.
There's no other information on that sheet that gives you any more information other than, in this particular case, a Glock 40 10mm firearm, correct?
Correct.
And I'll show all of them to you if you need to, but would you agree with me that out of the 6 that were sold from Beach's Pawn, 3, 50%, were Glock 10mm firearms?
Correct.
The exact model and the exact caliber, thank you, of firearm that you were looking for.
Yes.
Okay. And you didn't interview any of those 6 people, correct?
No, we did not.
You just looked and you saw whether or not they were associated in any way with a blue two-tone truck.
That's correct.
And if they weren't, you just scratched them off your list.
That's correct.
Mr. Fernandez isn't associated with a blue two-tone truck, correct?
No.
Do you have any records from any of the dozens or maybe 100 other licensed firearms dealers in the greater Jacksonville area that I can show this jury of how many other 10mm were sold?
I don't have numbers of that, and we developed no leads from any of the ones that were looked at.
You only looked at 6.
Correct.
No leads because you didn't talk to anybody, right?
Right. No leads were developed from them.
All right, I'm moving on. Now I'm asking you about all the other places. You have no other paperwork for me to show you or for me to enter into evidence to say, yeah, they went to 20 other licensed firearms dealers. They got another 100 Glock 10s, and they did or did not speak to those people. That does not exist in this case.
No.
You didn't go anywhere else and specifically look to associate anybody connected with Henry Tenon or anybody else regarding a 10mm in this case.
No.
You do know that Henry Tenon, on 2/9 of 2022, this is just days before the homicide, he did pawn some stuff, right?
Right.
Again, proof that Henry Tenon didn't have any money.
That's correct.
He's pawning he's pawning items that he owns. He's getting cash advances, correct?
Correct.
But a clue could be that in Defense Exhibit 20, this is a value pawn receipt. Can you see that?
Yes, sir.
You agree with me it's a value pawn receipt?
Yes.
You agree with me that the date is 2/9/2022?
That's correct.
You agree that it's Henry Tenon in the left-hand corner?
Yes, sir.
Okay. 8701 Old King Road, correct?
That's correct.
That's not the Potomac address.
No, it's not.
Did you ever go to Value Pawn and Jewelry, the very pawn store that you knew that Henry Tenon dealt with, to see if they had sold any 10mm firearms?
No, it did not.
May we approach without the court reporter, Your Honor?
Yes. All right, members of the jury, I've asked the lawyers, and both sides are doing a good job. I'm asking them on longer witnesses to kind of do what I would normally do, which is kind of pause at a natural point in their examinations. So I've been told by both sides that this would be a good pausing point. It happens to be right at noon, so we will take our lunch break now. So you're going to go into the jury room while we set up your lunch. Remember to follow the communication rules while you have your devices, and enjoy your lunch. We'll come back at 1 o'clock, okay? Okay, good afternoon. Are both sides ready to proceed?
Yes, Your Honor. If you want, so we don't have to waste any more time, just remind me of that sequestration issue. We can talk about it. We meant to tell you yesterday, we just forgot.
Can I see you really quick?
Sure.
That one. No, I don't need it to be on the record. Give me just one moment. Okay. I just gave them a heads up. We don't have to do it right now. We can do it at the end of the day. Okay? All right. All right, Detective Jones, you good?
Yes, ma'am.
Okay. All right, please let the record reflect that all defense attorneys, everyone is present, Mr. Fernandez present, all assistant state attorneys. We're in the middle of cross-examination. Both sides are ready. Mr. Holman, we'll get the jury.
Sneaking through my notes.
Let them know I'm going to address it at the end of the day, so it's not disruptive. Mr. Dreiser, about 2:15, I'm going to check in, okay?
Yes, Your Honor.
Thank you. All right, welcome back. Everyone may be seated. Welcome back, members of the jury. We hope that you all enjoyed your lunch. I think I heard some cheers when y'all went in. That's always a crowd pleaser, right? So both sides are ready to continue with the cross-examination, and Detective Johns is on the witness stand. Mr. Dreiser, you may proceed.
Good afternoon, sir.
Good afternoon.
So for a little context, I've been trying to go chronological. I asked you about January 5th, then I asked you some questions about January 25th. You recall that?
Yes, sir.
And just so the jury can understand what I'm doing and why I'm doing it, I'm not just picking random days, correct?
That's correct.
Those are days that you thought had evidentiary value, then you provided evidence to the FBI, and then they mapped those dates, correct?
Those were dates that we found stuff of evidentiary value that was provided to the FBI.
Exactly what I said, right?
Basically.
And those are the dates that I've chronologically gone through, correct?
Yes, sir.
So far I haven't skipped anything.
That's correct.
The next date is January 29th,
That's correct.
right? So that's where we're at now. So January 29th was a Saturday, correct?
I don't remember exactly what day it was. What day of the week it was, I apologize.
Okay. Any reason to dispute that it was a Saturday?
No.
Certainly, as you sit here as the lead detective in this case, you don't think it was a Wednesday.
No.
You haven't correlated like January 29th was a Wednesday, the homicide was a Wednesday. You take my representation, it was a Saturday.
Yes.
Certainly the government, if they find out I'm wrong, they can jump up and correct me, right?
Correct.
All right. So on the 29th, and I'm not going to go through all the detail. I understand Agent Blythe will tell you, this jury, what all these slides mean, but you're familiar generally what happens on the 29th, correct?
Yes.
All right, so let's walk through what happens on the 29th. Mario Fernandez, through his cellular data and timing advance records, which I'm going to save all for Agent Blythe, a way of tracking people, correct?
Yes.
Mario Fernandez goes from his home in Jacks Beach on the 29th over to the Potomac residence, correct?
Yes.
Now, one of the things I've spoken to you before, and you made it pretty clear this morning on what you're comfortable doing and what you're not comfortable doing, is whether Mr. Fernandez and Mr. Tenen are actually there at the same time and get there and are together before Mr. Tenen leaves Potomac, that's something we should save for Agent Blythe, correct?
He would be better able to explain the records to you, yes.
I appreciate that. But generally speaking, you agree with me that the records show that on January 29th, Mario Fernandez went from Potomac and he went from Marsh Inlet in Jacks Beach and he drove to the rental property that he owns at Potomac.
According to the slide, he is at what looks like to be Potomac.
But you know that he got there by going from his house, correct?
Yes.
Okay. Now, generally speaking, we know on that day that, well, generally speaking, you're not tracking people, correct? T-Mobile doesn't have a chip inside of Mario, correct?
Not that I'm aware of.
They're tracking devices, correct?
That would be a better question for T-Mobile. I'm not sure what they do and don't track.
I wasn't asking what T-Mobile was tracking. You, giving information to the FBI, you're tracking. These slides are tracking devices, correct?
These slides are based off of records that we've received from T-Mobile.
From the device?
Some of them from the device related, some of them from correlating cell towers.
I'm really not trying to play gotcha detective. They take the information that the device has via timing advance records, via geolocation, whatever the case may be, and then it tells you where they believe that device to be, correct?
That's correct.
And if it's geolocation, it's more precise than, for example, timing advance records, correct?
Yes.
And I said, I'll let Agent Blythe go all into this, but just generally speaking, these maps are tracking where individual devices that are associated with known people go, right?
Yes.
That's as basic as I can say, and you'll agree, right?
Yes.
So on this day, when I say Mr. Fernandez went from his residence to Potomac, the information is that his cellular device went from that residence to Potomac, correct?
Correct.
All right. You've said in previous affidavits, and you know that studies through all of your training experience have shown, is that people are generally within arm's distance or a wingspan of their device in this modern era, correct?
Generally speaking, yes, that is true.
Right. So when I'm asking you questions about the 29th, I'm asking you questions about where an individual's device is, and then the jury can make a decision as to whether the person was there or not there, right?
Yes.
In this particular case, we know that around 2:02 in the afternoon on that Saturday of January 29th, 2022, Mr. Fernandez's device arrives at Potomac, correct?
According to the slide, yes.
Is there any other slide that you'd like to see that would give any other contrary information?
No.
And you, of course, have reviewed these slides before.
Yes.
At the top, 904-566-2633, that's Mr. Fernandez's device phone number, correct?
Yes.
And at 2:02, in the area of the Potomac residence is where his device is.
That's correct.
Now, that device stays at Potomac until approximately, we'll go to a slide where we can get exactly where it is. Just tell me approximately. So about 4:23, correct?
Yes.
Okay. You have no information that that device ever left Potomac between 2:02 and 4:23, correct?
Correct.
Let's talk about Henry Tennant's devices.
Okay.
Henry Tennant's devices around 2:02, and we're going to let Agent Blight determine whether it's before that or after that, it leaves Potomac, correct?
Yes.
And Mr. Tennant's devices go all the way down to Nocatee in the area of where the victim lives, correct?
That's correct.
It drives around the gymnastics location where the children are, correct?
That's correct.
It then heads from that area over to the area of Sanctuary where this homicide occurred.
Correct.
Then it goes from the area where the homicide occurs back to Potomac, correct?
Yes.
In defense's opening statement, we told the jury that Henry Tennant murdered Jared Bridegan. Did you know that?
Only as of this morning.
Detective Johns, that evidence of what Mr. Tennant, the person who the defense is conceding is responsible for this homicide, went to an area where he otherwise doesn't normally go, correct?
That's correct.
That was evidence that suggested to you that that had something to do with this homicide, correct?
That's correct.
It then went to the actual homicide location, correct?
Yes, sir.
Henry Tennant was actually seen on video at the homicide location the night of the homicide, walking away from the homicide, correct?
That's correct.
So on the 29th, Henry Tennant's device, and by extension, the very concept that we just decided or agreed on earlier, is that most people are within arm's length of their device, correct?
Generally speaking, yes.
Okay. And that's why you believe Henry Tennant was with his device on that day, because he's with the device that goes to those locations, right?
Yes.
And then it leaves the homicide scene and it goes back to the Potomac area. No question, I think, in anyone's mind in this courtroom is that that had something to do with the eventual death and murder of Jared Bridegan, right?
Correct.
Okay. So now we know that Mr. Fernandez's device, and by extension of the studies, Mr. Fernandez's device is at Potomac. Mr. Tennant's device goes on this. If I called it a dry run, would you agree that that could be a proper term for this?
That was the term that was used, yes.
Okay. so I didn't make that up. The 29th, the dry run day, right?
Correct.
Okay. So now there are ways to determine if maybe someone isn't with their device, correct?
I'm not sure what you mean.
Okay. Let's say a device is pinging, or there are timing advance records that show a device is at Potomac.
Okay.
We'll use this very example that we're looking at right here. But then the surveillance would show that Mr. Fernandez is not at Potomac. That would be a way to determine if a person was not with their device, correct?
If we had surveillance, yes.
And that's my next question. You have no surveillance showing Mr. Fernandez with Mr. Tennant on that day, correct?
To be fair, we also have no surveillance of Mr. Tennant either.
Well, let's talk about what you do have. Because maybe someone could say, well, you don't have any surveillance of Mr. Tennant. You have license plate readers, right?
Yes, sir.
And you have license plate readers of Mr. Tennant's truck, correct?
That's correct.
So there was an independent way for law enforcement to go, we got Henry Tennant's devices traveling in this area that he shouldn't be on a location that's highly suspicious. And we have an actual picture of a truck registered to his father, his late father. That was independent evidence besides cell phone, correct?
Yes.
You don't have any independent evidence that Mr. Fernandez was with Mr. Tennant when Mr. Tennant did whatever he did on the 29th, correct?
That's correct.
You don't have a receipt where Mr. Fernandez purchased something outside the area of Potomac while his cell phone was at Potomac, correct?
Correct.
You said yesterday that dozens of swabs were taken of the inside of that blue truck, correct?
Yes.
The blue truck, by way of the license plate readers, is the vehicle that was used to go on that dry run, correct?
Correct.
There's not a single shred of evidence that puts Mr. Fernandez inside of that blue truck, correct?
There is no physical evidence that puts him inside the truck.
There's no DNA, right?
Correct.
There's no fingerprints, right?
Correct.
Mr. Fernandez at the time, from what we saw in the interview, he had long hair. It was up in like a man bun, correct?
From the time of the interview, correct.
At the time of the interview?
Yes.
2 weeks after the homicide?
Yes.
No way he could have grown that hair that quickly, right?
Probably not.
You're a detective. Use your detection skills. In 2 weeks before your interview, Mr. Fernandez had long hair, correct?
Yes.
Special vacuums were used to vacuum out the blue Ford F-150 to find hairs so they could test them, correct?
That's correct.
Not a single one of Mr. Fernandez's hairs were in that car, correct?
Correct.
Certainly there was no evidence that that Ford blue F-150 was cleaned. Like, after a crime, some people may wipe out a kitchen floor or a vehicle or a handgun or whatever the case may be. That car was in pretty rough condition, correct?
When it was found months later, yes, that's correct. True, it was.
It didn't look like it had been cleaned out.
No.
Let's look at evidence that we do have. We just spent some time talking about digital evidence that would show that Mario Fernandez was at Potomac from 2:02 to approximately 4:23. That's what we talked about, right?
Yes.
Now, we certainly can agree that Mr. Fernandez owned that property, correct?
Correct.
We certainly agree that's a place where it's not he has a connection, a very big connection to that property, right? It's not unusual that a landlord would go to a place that he owned, correct?
Not unusual, no.
Let's also kind of revisit some of the history that we know about this case. It's the 29th, so it's one of the last days of the month, right?
Yes.
And it's also 2 days after and approximately 1 day before the new tenant, Mr. Ordway, is moving in, correct?
I know he moved in sometime in the month. I don't know exactly when.
It's the end of the month, and it's right in the middle of a transition of tenants, correct?
Yes.
The one thing we know for sure is it's 2 days after that lease was signed.
Correct.
And you know that all of the stuff that Mr. Tennant had when he was living there was moved into the garage.
Yes.
Because when you searched it, all the stuff you found was in the garage, correct?
That's correct.
It's not a foreign concept that the landlord may have gone to make sure all the stuff was put where it was supposed to go, correct?
That's correct.
And of course, it's not normal that a person would leave and leave stuff there, except for in this scenario, as we talked about, Jeremy Ordway and Henry Tennant were close family friends.
That's correct.
Okay. What is a pole camera?
It is a camera that is put on top of a pole.
Pretty simple. And in this case, pole cameras are law enforcement tools.
Yes.
Okay. I'm sure it could be anybody, but when I say pole camera, I'm talking about the pole cameras that law enforcement use as an investigatory tool in the investigation of this homicide, correct?
Yes.
You guys put up pole cameras at Potomac.
Yes, that's correct.
You put up pole cameras at Marsh Inlet.
That's correct.
You put up a pole camera, where else was there a pole camera? I think in Orlando.
No.
There's another pole camera somewhere.
The one off of Beach Boulevard.
Okay. You guys put up a few pole cameras. I'm going to focus on Potomac for the moment, right?
Okay.
You didn't tell Mr. Fernandez that you put up a pole camera, correct?
Correct.
They're done as a way of trying to find evidence. You don't put anybody on notice that you're doing that, right?
That's correct.
And in this case, you put up a pole camera sometime in August of 2022.
Yes.
Detective Johns, I'm going to represent to you that the defense in Exhibit 33, okay? Let me show this to you. Yeah, approach 7. You said I can move around, right?
Sure.
May I approach?
Yes. What exhibit is that?
I said 33, but it's 31.
Okay.
Mistake. Sorry. Detective Johns, can you see Defense 31?
Yes.
And this looks like a big old multi-terabyte jump drive.
Yes.
And there's a plug that goes in the computer, and there's a plug in the back.
Yes.
Okay? I'm going to represent to you that all of the poll camera, for all of the months that it ran at every single location, is on this, and it's in evidence by the defense, okay?
Okay.
So when I say I'm showing you some clips here in the next few minutes, I want you to know that if there's anything else that you think that they need to see, it's in evidence. They can look at anything they want. Fair enough?
Yes.
And then just so everyone understands how we're looking at this, this is defense 32, 33, and 34. Looks like a little jump drive.
Yes.
A little mini one of the big guys.
Yes.
And this has a number of clips from when you put up the poll camera where you captured Mario Fernandez at Potomac. Oh, we're going to look at it, but you understand that that happened, correct?
Yes.
You know what I'm talking about, correct?
Yes.
So if we're trying to figure out if Mr. Fernandez would ever go to, well, let me back up. There is no poll camera on January 29th, because that precedes the homicide, correct?
Correct.
So you don't know what Mr. Fernandez was doing because there's just no surveillance of it, right?
That's correct.
So one way in law enforcement is we look, I think you said yesterday there's victimology. Do you recall that?
Yes.
Victimology is looking sort of at the past to see if there's any connections, right?
Yes.
So one of the things that you said was, I'm looking to see if it's a random act of violence. I looked at the victimology to determine that it was or it wasn't, right?
Correct.
Well, in the same concept, in the same vein, if Mario Fernandez's vice is at Potomac on the 29th, and we have to kind of determine, is that unusual? Is that common? When you put up that poll camera, that could help answer some of those questions, correct?
I don't understand.
Well, let's find out. Did Mr. Fernandez go to Potomac?
Yes, he did.
Okay, so let's look at Defense Exhibit 33. That's the little guy I showed you, right? Are you aware that Mr. Fernandez, when you put up the poll camera in August, in the first 30 days, there are 20 different times that Mr. Fernandez went to the Potomac address?
I'm not sure how many times he did or did not go.
Okay. When we see him on these videos, I assume you don't dispute the poll camera footage, do you?
No, I don't.
Okay. Now, one of the other questions is, why would Mr. Fernandez go to Potomac? So let me ask you some questions. Potomac had some disrepair, correct?
Yes.
Like we talked about earlier, you were able to confirm that Mr. Fernandez was engaged in working on especially those tile floors, correct?
He was making repairs to the home.
No question about that.
No.
His bank records reflect that that's the case, right?
Yes.
The poll cameras reflect that that's the case, correct?
Yes.
Messages between Mr. Biggerstaff and others confirm that that was the case?
Yes.
So what are we looking at here? Oh, I haven't published it yet. May I publish Defense Exhibit 33, and I'm starting with A, Your Honor.
Yes.
Can you see that, Detective?
Yes, sir, I can.
Okay, can you pause it, Ms. Day? All right. Is this the poll camera located at Potomac?
Yes.
And is that the driveway leading to Potomac?
Yes, it is.
And when I say Potomac, we're talking about the residence that Mr. Fernandez owned. I don't need to keep saying the address, right?
Correct.
Okay. What kind of car or truck did Mr. Fernandez own in 2022?
A Toyota Tundra.
What color?
It was white.
What do you see in the bottom right corner?
White Toyota Tundra.
That's the driveway at Potomac?
Yes.
Whose red car is backed up?
Mr. Ordway's.
The tenant.
Yes.
What time is it?
It is 7:45 a.m.
Okay. A little early in the morning.
Yes.
You learned, and if you can't remember, it may refresh your recollection, that Mr. Fernandez would come sometimes early in the morning, and depending on what work he was doing, he may come back multiple times in one day, correct?
Yes.
not to bore everyone to tears, I'm going to scroll forward, okay?
Okay.
If at any time, I'm sorry. I don't want to do that. Let me start over. We're going to scroll forward a little bit, okay?
Okay.
If at any given time you think I'm scrolling forward and missing a fact that you think is important, will you agree to tell me so I can make sure the jury sees it?
Yes.
Any reason to dispute that that's Mario Fernandez?
No.
You could see that someone got out and walked into the residence, correct?
I mean, I didn't see that specifically, but I don't doubt that he was there.
Can you look right? Oh, can you see right there?
Yes.
No reason to believe that's not Mr. Fernandez.
No.
Those are better views where you could really identify that was in fact Mr. Fernandez, correct?
Yes.
Okay. This is many months after the homicide, correct?
Yes.
Mr. Tennant has not been arrested yet, correct?
I don't believe so.
8/9/2022 to
No.
Okay. But Mr. Fernandez is not distancing himself from the Potomac home as far as you can tell, right?
No.
This was after the tire was collected, correct?
Yes.
Jeremy Ordway's home, he knows the law enforcement came and collected that tire.
Yes.
You can kind of see his man bun there. Detective?
Yes.
I think it skipped or looped, but Mr. Fernandez left. The vehicle pulls out. You don't dispute that, right?
No.
Do you want to see it?
No.
Pulling out? He was there approximately 20 minutes or so, correct?
Correct.
Okay. And that was on 8/9/2022. I'm now going to show you another clip from the same day. Defense Exhibit 33B. Thank you, Ms. Stifler. I really appreciate that. Okay. So, is it published? Yes. All right. Same day, 8/9/2022, right?
Yes.
Same poll camera, correct?
Yes.
Same house, correct?
Yes.
2 p.m., 2:04 p.m., right?
Correct.
Mr. Ordway's vehicle still in the driveway.
Yes.
Pause. Okay. Mr. Fernandez's vehicle?
Yes.
This stuff, this time, it has boxes of construction materials in the back, correct?
There were boxes of something in the back.
Okay. Push play. Let me say the boxes are consistent with the work that you knew he was doing at Potomac, correct?
Most likely, yes.
Thank you. Right, this time you can see Mr. Fernandez pulling out, correct?
Yes.
So he came back a second time in the day. Looks like 2 people got out of the vehicle. And all the stuff that was in the back of the vehicle is no longer in the vehicle when it pulls out.
That's correct.
Doesn't take a rocket science to determine that they dropped off what they had brought over.
Correct.
I'm now going to show you a video from August 16th. It's about a week later, correct?
Yes.
Defense Exhibit 33C, Your Honor.
Thank you.
Detective Johns, same house,
Yes.
same poll camera.
Yes.
It's 8/16/2022,
Yes.
and it's 6:43 p.m.
That's correct.
Jeremy Ordway's vehicle is in the driveway.
Yes.
There's a white Crown Vic in the driveway.
Yes.
Tell the jury whose white Crown Vic that is.
Mr. Ordway's father,
Right? And who was known to drive that vehicle.
Mr. Tennant.
Mr. Tennant had not been arrested yet, correct?
Correct.
Stop. A week later, and Mr. Fernandez's vehicle pulls up, correct?
Yes.
You're not disputing that's Mr. Fernandez?
No.
You're not disputing that there's more materials in the back of the car?
No.
The bed of the truck, excuse me.
No.
Those are consistent with the same type of construction material. Well, I'm not going to say, we don't know. Same boxes that were dropped off and unloaded back on August 9th, correct?
Yes.
Pause it. There's a black dog. Do you see that?
Yes.
Tell the jury whose black dog that is.
It's Mr. Tennant's dog.
That's the same dog that when Mr. Tennant was arrested was with Mr. Tennant, correct?
That's correct.
It's the same dog that we heard from Detective Burrell when Mr. Tennant got out of his car. He put a dog bowl down. You weren't in here, but I'm sure you know that from Detective Burrell.
Yes.
It's because Mr. Tennant had a little black dog, or a medium-sized black dog.
Yes.
Okay? No dispute, Mr. Fernandez got out of his vehicle?
No.
That is Mr. Fernandez.
Yes.
appears Mr. Fernandez got a couple white bags out of the back of his cab,
Yes.
and he appears to be carrying those white bags into the Potomac rental property that he owns, correct?
Yes.
Go very slow. Okay, stop. All right, Detective Johns. That's Henry Tenen, correct?
Yes.
So on 8/16, some 6 months post the homicide, Henry Tenen comes out of the Potomac address home, and he's going to start unloading construction materials from Mr. Fernandez's truck and bringing him inside, correct?
Yes.
Mr. Fernandez is with Mr. Tenen. He hasn't distanced himself from Mr. Tenen, correct?
No.
They're on camera together.
Yes.
Mr. Tenen is doing something for Mr. Fernandez. I mean, he's laboring for him, correct?
Helping unload a truck at least.
You heard in phone calls and wire calls and Sonny Fong's call that Mr. Fernandez, according to Mr. Fernandez on the wire call, that he paid Mr. Tenen to do work for him, correct?
Yes, that's correct.
And then, of course, unbeknownst to what he said on a call, you have no reason to believe Mario Fernandez knew that his phone was being tapped on that T9 wire you talked about yesterday, correct?
I don't have any evidence that he knew.
And you have no evidence to believe he knew he was being recorded here, correct?
No.
Can you stop it? We have a new character I'd like you to introduce the jury to.
I believe that's Mr. Ordway.
And that's the dog jumping up on Mr. Ordway?
Yes.
So this is now some evidence that when we see his car there, it's not some kind of ruse. Mr. Ordway is there because you see him there on the poll camera.
Yes.
You learned through this investigation that Mr. Ordway was a pizza delivery man?
That's correct.
Okay, and he worked typically in the evening hours, correct?
That's correct.
And that's Mr. Tenen unloading those materials, whatever they may be, from the truck.
Yes.
Now, again, we don't know by looking at it, but you do know at this time, this is when the text messages are flying back and forth about the tile, correct?
What do you mean?
The tile floor that needed to be done at Potomac.
Yes, sorry.
And then another little clue that we could look at is in evidence, the state put photos of Potomac and it needed tile flooring. It was ripped up.
Yes.
So there's text messages about tile work that needs to be done at Potomac. The pictures confirm tile work needs to be done at Potomac. And then you have this construction material in and around the same weeks of time that these conversations are happening. It's not a leap of imagination that those could be tile. It would be consistent that tile would be being dropped off, right?
That's correct.
And I'm not going to jump the gun here. I know this is exciting, but we're going to see tile work being done at Potomac on the poll camera. We're going to see a wet saw, right?
Yes.
And you're going to see the water running down. That's going to tell us that they're doing tile work at Potomac, right?
I would assume so, yes.
All right. are watching this, for more context, this is 2 days before Henry Tennant gets arrested.
Yes.
And Mr. Tennant was arrested driving while license suspended or revoked. We heard that yesterday, right?
Yes.
And then there was some old shotgun that he wasn't charged with, but they ended up arresting him for, right?
That's correct.
And that was the white Crown Vic that he was pulled over in.
That's correct.
Mr. Fernandez leaves on that day. No dispute as to that?
No.
And the materials are gone?
Correct.
Now I'm going to show you Defense Exhibit 33D. This is August 17th, 2022. And that's 1 day later, correct?
Yes.
Not to be so redundant, but it's 7:48 in the morning, right?
Correct.
So we've seen him there in the evening hours, we've seen him there in the morning, and we've seen him there in the afternoon, correct?
That's correct.
It's Mr. Fernandez's truck, right?
Yes.
No dispute it's Mr. Fernandez?
No.
And no dispute that Jeremy Ordway's vehicle is parked in the driveway?
That's correct.
Okay. Now, on the 29th, you follow me? I don't want it to be too confusing. The day that Mr. Tennant does whatever he does on that dry run, that would be an example of when Mr. Fernandez could be at Potomac and there not being a tenant there, correct? Because if Mr. Fernandez is with his cell phone, and the jury will make that determination, and Mr. Tennant is with his cell phone, then possibly Mr. Fernandez would have been at Potomac without the tenant being there, right?
It is possible that Mr. Fernandez would be at a rental property without the tenant being there, yes.
Okay, but now I just want to show you that we don't have to guess whether it's a possibility, because we're going to see it. Record this. For the record, this is Defense Exhibit 33F, if I did not say so.
Thank you.
Did you go too fast? That appeared to be Mr. Ordway walking by his vehicle?
I can't really tell.
Okay. Skinny white guy matching the description of Jeremy Ordway?
Probably Mr. Ordway.
Looks like
It's probably Mr. Ordway.
And it looks like he was getting into the vehicle that you know Mr. Ordway to drive.
Yes, that's correct.
Okay, and at 8:09, 43 seconds, Mr. Ordway gets into his vehicle and he backs out and he drives away from the Potomac address. Is that a fair description of what you just saw?
Yes.
This would be an example of when Mr. Fernandez would be at the rental property while a tenant leaves and he remains, correct?
Yes.
Go forward. Okay. Stop. In the very first video I showed you, we knew that Mr. Fernandez went to the property. We knew he stayed about 20 minutes, and then he left. Fair to say, I couldn't tell you what he was doing there, right?
Correct.
You couldn't tell me what he was doing there, correct?
That's correct.
Seems consistent that he goes there to do work or arrange for work to be done, but we didn't know that, right?
I don't know why he was there.
Right. But in this video, who just pulled up?
Bueller Air Conditioning.
Okay. So does that give you a clue that maybe he was there to meet a vendor who's performing work on the property?
That's a fair statement.
And in fact, when you went through Mr. Fernandez's First Choice Home Rentals business account, at the same time that this was happening, there was receipts from Bueller Air Conditioning, correct?
Yes, that's correct.
And in fact, at some point prior to this, they had put in an entire new air conditioning unit at Potomac.
Yes.
And it was Bueller that put it in.
Yes.
So this all sort of makes sense, right?
Yes.
Here's that was the Bueller air conditioning man going in, coming out,
Yes.
doing work at the property.
Yes.
Here's Mr. Ordway, comes back to the property.
Yes.
Camera shows Bueller left,
Yes.
and shortly thereafter, Mr. Fernandez backs out and he leaves.
Yes.
Well, I guess he doesn't back out because he backed in, he pulls out.
Yes.
So in a situation where the jury may be left guessing what is going on the 29th, these, via poll camera, we can really deduce with evidence that Mr. Fernandez goes to his rental property for legitimate reasons, correct?
I can say that these show that he does go to the rental property for legitimate reasons, yes. I don't think it's a representation of necessarily what happens on the 29th.
I know you don't want to believe that. I'm asking what these videos show as compared to there not being video cameras on the 29th, correct?
Just clarifying my answer.
Okay. So if I were to make an argument, well, maybe he went to his rental property, we now know, and there is no dispute, that he goes to this rental property, right?
No, that's not in dispute.
He's not an absentee landlord, correct?
No.
Okay. So now let me show you another video from Defense Exhibit 33F. We just did that one? No, I don't think so. And if it wasn't clear, there were no cameras at Potomac on the 29th.
That's correct, there was not.
Now, pause it. This is another poll camera from 8/27/2022 at 6:08 p.m. Okay? Same poll camera?
Yes.
Same address?
Yes.
What's important about this date is we can all agree Mr. Tenon has been arrested, correct?
Yes.
And you don't dispute that although Mr. Tenon was arrested for a driving offense, law enforcement went to Potomac that day and spoke to Jeremy Ordway, correct?
That's correct.
Detectives from the homicide unit, Detective Cullen and your partner, Detective Lamont, arrived and they told Jeremy Ordway that Henry Tenon was arrested in connection for the murder of Jared Bridegan, correct?
Yes.
Okay. So, Mr. Fernandez, he knows at this point that Henry Tenon had been arrested
in connection to the murder of his wife's ex-husband, correct?
I would assume so, yes.
Right. We have to assume that. And I'm glad that you agree. And yet, even with that fact, Mr. Fernandez doesn't distance himself from the Potomac address, does he?
No.
No, because this is... All right, pause. Detective Johns, let's introduce a new character to the jury. Whose vehicle is that?
I'm actually not sure whose vehicle that is.
If I told you it was John Biggerstaff's vehicle, is that...
Oh, that's right. Yes, it is. I apologize.
Okay, so we don't disagree that's John Biggerstaff's vehicle, right?
Yes.
And again, you know, because of other investigative efforts, that John Biggerstaff was to perform tile work at the Potomac. We've talked about that.
Yes.
And now we see John Biggerstaff showing up at the Potomac address, right?
Yes.
And if I didn't ask you, early in the video, you saw Mr. Fernandez. This time he parked on the grass?
Yes.
Okay. So he's there as well?
Yes.
And just so there's no confusion, can you see the black dog?
Yes.
And you can see the Crown Vic, correct?
That's correct.
Can you pause it? Because this is important, but I want to make sure everyone understands the facts. Henry Tennant's in jail.
Yes.
They allowed him to park, instead of his vehicle being towed, someone took it and put it back at this address, right?
I believe Mr. Ordway came and got the vehicle.
Right. So just because we see the vehicle this particular time, we know Henry Tennant is not there.
That's correct.
And although we see his dog, we know he's not there because Mr. Ordway agreed to take custody and possession of Henry Tennant's dog after he got arrested, right?
That's correct.
Just another little piece of proof that they were friends, right?
Yes.
And Judge, if we could just get through this video, if that's a natural break for you. You told me at 2:15.
Yes, but before we do, I want to check in with you all for scheduling purposes.
Yes, ma'am. I was just giving you a heads up. I'm okay if you want to at the end of this video.
Okay, thanks.
All right. Before she puts play, can you see Mr. Fernandez?
Yes.
Okay. So we saw him pull up earlier, then we saw Mr. Biggerstaff pull in, and then it looks like Mr. Fernandez got out of his car to go meet Mr. Biggerstaff. We can deduce that?
Sure.
Okay, this is well after the homicide, correct?
Yes.
Some argument is to be made that John Biggerstaff actually gave Mr. Fernandez a 10mm firearm to effectuate the murder of Jared Bridegan. If the government decides that they're going to make that argument, this video shows us that well after the homicide, Mr. Fernandez did not distance himself from Mr. Biggerstaff, correct?
That's correct.
Well, the jury is watching this. Your Honor, I'm sorry, can I just have a few more minutes after this video?
Yes.
There's a connected video I'd like to show. Scroll. You can see that that is in fact Mr. Biggerstaff?
Yes.
Okay. Approximately 7:04 p.m., Mr. Biggerstaff's vehicle backs out and appears to leave?
Yes.
And then shortly after, Mr. Fernandez leaves, right?
Yes.
I want to show you Defense Exhibit 32B. This is the following evening. This is 8/28/2022. It's 9:18 p.m., correct?
Yes.
And this poll camera ran continuously, correct?
Yes, it did.
It wasn't motion activated. It caught everything that happened at that residence.
That's correct.
Can you kind of scroll until Biggerstaff gets there? Okay. Pause it. Appears to be Mr. Biggerstaff is back, correct?
Yes.
You can scroll forward. Now, this video is about 3 hours and 20 minutes on 8/28/2022, right?
Yes.
You can see that by looking at the bottom.
Yes.
And this is the night that Mr. Biggerstaff goes over there and starts performing tile work, right?
Allegedly, yes. I mean, I can't see what he's doing, but
Well, we talked
whether
about
they
that.
spoke about doing tile work.
We talked about that wet saw, right? Right. Well, there's more videos, so let's break it down. You say you don't know what he was doing. Fair enough. I'll give you that. He meets up with. Okay, we can agree that you don't know what he was doing there that day.
No.
It's the day after he met Mr. Fernandez at the property, correct?
Yes.
They appeared to have a meeting in the driveway where they were talking, correct?
Yes.
The next day, Mr. Biggerstaff shows up, correct?
Yes.
Mr. Fernandez does not show up, correct?
That's correct.
So whatever Mr. Biggerstaff is doing at the Potomac address, he's not doing it with Mr. Fernandez, correct?
That's correct.
Yes. I'm going to now show you a video after midnight, the same time that he's there, Defense Exhibit 33G. Is that right? Can you see the bucket?
It's hard to make out what it is, honestly.
Trying to speed this along, but would you like to watch more to determine if you can see if that's a bucket and there's water all over the area where they're working?
It appears to be a bucket, and it appears that there's water on the ground.
Okay. And that would be consistent with the tile work that we talked about using a wet saw, right?
Yes.
Stop. Can you see Mr. Biggerstaff dumping the bucket now?
Yes.
You can see all the water coming out.
Yes.
A moment ago, you said, well, I don't know what he's doing there. Now we have some idea what he's doing there, right?
At least parts of it, he appears to be using a wet saw.
He appears to be working, right?
Yes.
Good scroll. Now, at this point, you can see water that's now dripped all down the driveway, right?
Yes.
That was not there before, correct?
Correct.
And if we sat there and we watched this entire thing, you would see the progression of water from where Mr. Biggerstaff is working, pouring into the street, right?
Yes.
And then Mr. Biggerstaff leaves.
Yes.
Your Honor, this would be a natural breaking point if...
Okay, let me just see the lawyers at sidebar. So members of the jury, let's do 10 minutes, and then I'm going to take another really short break because I think maybe from the state's perspective, there will be some setup. Is that right? Yes, we have to test this. Right, okay. So we'll take 10 minutes now, okay, and then I'm going to give you another shorter break to set up for setup purposes, okay? So we'll come back at like 2:32, okay? Leave your notepads on your chair, please. All right, please let the record reflect that the jury's left the courtroom. Detective, you can take the break, okay? And I will tell you that because of scheduling, I'm going to tell the jury when they get back, we're going to pause your cross-examination and take a couple of witnesses out of order and then continue your cross-examination, okay?
I'm sorry, Judge. I thought you were going to let me finish my.
I am.
Oh, I didn't. I'm sorry, I wasn't paying.
No, I'm sorry. Like, we're going to come back. He's got some more questions. We're going to pause it and then, because of some scheduling issues, okay? All right. So just follow the rules over the break.
Yes, ma'am.
All right. Everyone, the court's in recess.
Hello, sir. My name's Alan Mizrahi. I'm an assistant state attorney. Can you hear me? Can you hear me, sir? Can you hear me, sir? All right, if you can hear me, say yes.
The house.
You don't recall that John Biggerstaff was frustrated that Mr. Fernandez was making him do it on his time schedule, and that's not what they agreed on?
That's correct. Actually, yes.
Okay, that did refresh your recollection?
Yes.
Thank you for acknowledging that. So, as it turns out, around this time, Mr. Biggerstaff and Mr. Fernandez stopped communicating and doing work together. That's what you learned.
Correct.
And consistent with what you learned through looking at text messages and, all those things that you were able to determine, interviewing John Biggerstaff, you then know that on the poll camera, Mr. Fernandez starts coming to finish the tile work, correct?
I know he starts coming to the house.
Let's see what we can determine from the poll camera, okay? This is now August 31st, 2022, 11:50. This is the Potomac address, black dog, and Mr. Ordway's vehicle in the driveway, correct?
That's correct.
Here's Mr. Fernandez shows up this day.
Yes.
You can see Mr. Fernandez there?
Yes.
Mr. Fernandez appears to be standing in the back of the bed of the truck, and he's looking up at the roof.
I see him standing in the back of the truck. I don't know what he's doing.
All right. Stop. Does he appear to now be on top of the car, staring at the roof of the home?
He is on top of the car staring at something. I can't say what he is or isn't looking at.
Fair enough. If you were standing in front of Potomac, just because you've been there, correct?
Yes.
And the jury hasn't, you can see part of the house to the driveway to the right, correct? I mean, you can see the driveway to the right of Mr. Fernandez.
Yes.
In this particular setup, the house is on the side that Mr. Fernandez was looking at, not the other side of the driveway. And so the record's clear. The right side of the driveway, looking at this poll camera footage, has no house. The house is on the left side of the driveway, correct?
The driveway leads to the garage. The main structure of the home is on the left side.
So you understood my question and you agree with me?
Yes.
Thank you. Mr. Fernandez appears to leave the property, correct?
Yes.
Okay. I'm going to show you September 2nd, 2022. Defense Exhibit 33H. Let's move pretty quick. See the palette, right? I think we're close to that. No, that's September 4th. So the record's clear. This is September 2nd, 2022. This is 11:56 a.m., and Mr. Fernandez appears to be showing up at the rental property.
Yes.
You agree with that?
Yes.
And so far, everything I've showed you is within the first 30 days of you putting up this poll camera, correct?
Yes.
Well, 16 approximately, Mr. Fernandez appears to be leaving the rental property, correct?
Correct.
Okay, now I'm going to show you 33I. It's the same day, correct?
Yes.
The video I showed you before was a different time, but it was 9/2, September 2nd, 2022. This is a little bit later in the afternoon, correct?
Yes.
It shows Mr. Fernandez showing up again, correct?
Yes.
Without going into the specifics of some of those other days that I talked to you about, and some in which we haven't gotten to yet, January 5th, January 25th, January 29th, February 15th, February 16th, some of these important days that are days that you were investigating. We talked about that earlier, correct?
Yes.
One of the things that you know Agent Blythe is going to testify to is that on certain days you have Mr. Fernandez, by way of his cellular device, going to the Potomac address more than one time, correct?
Yes.
For example, on February 15th, he goes there in the morning, and then on February 15th, his cellular data shows that he goes back in the afternoon, correct?
I'm going to let Agent Blythe answer those questions. I don't know what he is or is not going to testify to.
Fair enough. I'll show you the slides from that day, and then you can tell me with your CAS training if it shows Mr. Fernandez going twice. And I think we've talked about it before, and you let me know, okay?
Okay.
Again, while Mr. Fernandez is there, Mr. Ordway's vehicle pulls out and leaves, correct?
That's correct.
Doesn't appear to have any other vehicles in the driveway besides Mr. Fernandez, correct?
That's correct.
Another example where Mr. Fernandez may be at the residence while the tenant is currently not there, correct?
Correct.
And in this daylight video, you can see that orange bucket in the near location by the door to the residence, correct?
Yes.
Go to the next one. And Mr. Fernandez's vehicle leaves, correct?
Yes.
Okay, I'm going to show you the next numbered 33I. It's the same day. It's at 8:31 p.m., correct?
Yes.
Okay. And again, Mr. Fernandez's vehicle shows up. Can you see the truck bed?
Yes, again.
Okay, go forward. Looks like Mr. Ordway's vehicle is there.
That's correct.
So your poll camera evidenced Mr. Fernandez going 3 times in one day on September 2nd, 2022, correct?
Yes.
Next, I'm going to show you 33L. This is now September 3rd, the next day at 1:55 p.m.
Yes.
Mr. Fernandez pulls up.
Yes.
You can see Mr. Fernandez there briefly.
Yes.
9/3, Mr. Fernandez leaves, correct?
Yes.
I'm going to show you September 5th, 2022, 33M. 33M. Okay, I'm going to go back to 9/4, 33L. In this particular video, at 1:18, while Mr. Fernandez is there, do you see a trailer pull up?
I see a trailer in the frame, yes.
And what's stacked in the back of that trailer?
Pallets?
Okay. And that was the business, although Mr. Tenon has been arrested, that's the business that Mr. Tenon was in, the pallet company, correct?
He worked at Monison Pallets.
Right? And through your investigative efforts and all the evidence that's been admitted by the state attorneys, Mr. Tenon was interested in starting a pallet business. You learned that, correct?
He did have some interest in starting a business, yes.
Okay. And then you were able to look through some of the paperwork that you found in his possession, correct?
Yes.
Okay. You found ledgers that indicated that he had detailed notes about costs and pallets and things of that nature?
I know he had the notebook that you're holding in your hand that had some figures in it.
Okay. That's one of the notebooks that had figures, but this, just for the record, where did I pull this out? It's from States 197. And I'm looking at a composition notebook.
Is that 197? Okay.
Okay, so some of the photos that aren't contained in this that you referenced, which are other ledgers and things of that nature, are also contained in States Exhibit 197, okay?
Okay.
But I'm holding up what was also pulled as part of that composite of States 197, a blue composition notebook. And publish that. I'm showing you what's on approximately the third page of that States 197. Can you see that, Detective Johns?
Yes, sir.
It says business plan, right?
That's correct.
Name of business, Tenon Pallet Recycling, period, correct?
Yes.
Location, Drayton, Georgia, period, correct?
Yes.
Henry Tenon has connections to Georgia, correct?
Yes.
His family and his father live there.
That's correct.
Action number 1, collect pallets for repair and materials. See that?
Yes.
Truck and trailer needed for this action, period, correct?
Yes.
Number 2, repair pallets to be sold. Correct?
Yes.
Air compressor, nail guns, staple guns. Those are supplies.
I would assume.
Number 3, dismantling pallets for materials, period. You agree with that's what it says?
Yes.
Mr. Tenon didn't write that since he's been in jail. You know that, right?
Correct.
So that was written prior to him being arrested, and this was found at Potomac, correct?
Yes.
So we don't have to guess whether Mr. Tenon, at least in his mind, wanted to start a pallet company, correct?
According to his notes, it seemed like he did want to start a pallet company.
He had a name for the pallet company, right?
Yes.
He had, albeit pretty simple, he had an action plan, right?
Yes.
Mr. Tenen wasn't an extremely educated person, was he?
I'm not sure of his education.
You're the lead detective in a homicide case where 3 people were arrested for a homicide. Any reason to believe Mr. Tenen had a college degree?
No.
Okay. He was a day laborer?
Yes.
Nonetheless, he had an action plan, he had supplies consistent with a business plan, and he had things that he wanted to do in order to effectuate a company with a name and a location. That we can determine from that composition book, correct?
He did have the notes in the composition book. I don't believe he had any supplies that I'm aware of.
He listed supplies.
Yes, he did.
I'll come back to that. I digress, but at 1:18, after he's arrested, on poll camera, a truck with pallets does arrive at the Potomac address.
There was a trailer with pallets in the frame.
Okay. Maybe it's not clear. Like I stopped it right when it was driving by.
Mm-hmm.
You want to see it so that you can see that it stopped there? So just back it up a little bit. Can you tell that I'm scrolling minutes and it's still there? You can't. It's okay.
Looks frozen on my screen.
Maybe it is. Let me see. Can you tell it's not frozen now?
Yes.
Can you tell that's not moving?
Yes.
Definitely stops in front of Potomac.
It would appear that's true, yes.
While Mr. Fernandez is there.
Yes.
Okay, go back. All right, stop. That orange bucket that we keep talking about, it was in the frame earlier up in the top left corner, right?
Yes.
Now you see Mr. Fernandez, he grabs the bucket, comes to the end of the driveway, and he dumps all the water, right?
Yes.
The same thing Mr. Biggerstaff did about the time he was leaving the Potomac address, correct?
Appears to be a similar action.
Okay. Where do we leave off? Then pull forward. And again, around 1:46, Mr. Fernandez leaves the property, correct?
Yes.
Exhibit 33M. For the record, Defense Exhibit 33M, Your Honor.
Thank you.
This is 9/5/2022, the following day, correct, Detective?
Yes.
Mr. Fernandez shows up, right?
Yes.
You can see his truck.
Yes.
Roll. It's at the end. it's in evidence. On 9/5, he's there and he leaves again. Is that correct?
Yes.
The following day, September 6th, Defense Exhibit 33N. Mr. Fernandez shows up, Detective.
Yes.
That orange bucket you can see moving in the corner again.
I haven't seen it move.
Jury can determine, I suppose. Maybe let it catch up and then scroll again. Show leaving for him. Nonetheless, he's there, he leaves, correct?
Yes, sir.
Defense Exhibit 33O. This is the same day, 9/6/2022, but it's later at night, correct?
Yes, sir.
Mr. Fernandez arrives.
Yes.
I know we're going fast, Detective, but in the upper left-hand corner, can you see the bucket moving back and forth? It appears that work is being done.
I did see it this time, yes.
Try and move it along. You can see the bucket come into frame. You can see it come out of frame.
Yes, sir.
All right, thank you. There it is. Okay. You see Mr. Fernandez in the bottom right-hand corner with the bucket, and he's dumping it?
Yes, sir.
Okay. And this is about 2 minutes before he leaves the residence. Detective?
He hasn't left yet. I'm assuming
I guess if you look at the bottom right-hand corner, you can...
there's 2 minutes, 19 seconds left of the video.
All right, but in fairness, you don't know that I cut it where he leaves, so we can scroll to it. I understand. Okay, he's now gone at 11:22.
Yes.
So he stayed there, and it looked like he was performing work for a couple hours.
Yes.
September 8th, 2022, Exhibit 33P. This is now in the morning, Detective?
Yes, sir.
Mr. Fernandez appears, his truck gets there around 10:30-ish.
Yes.
That's all right. So easy to find last time. All right, there it is. See Mr. Fernandez again with the bucket coming out.
Yes, sir.
There seems to be a theme that Mr. Fernandez is going there and he's doing tile work, correct?
I can't say what he is or isn't doing inside the home. He is carrying a bucket over several repeated days in and out of the house and dumping some water.
We can't say, but with all the evidence that you have, it's not inconsistent with him finishing the tile work that John Biggerstaff was contracted to do, correct?
That's correct.
Move to Defense Exhibit 33Q. Timestamp pills. In this video, is that Mr. Fernandez?
It appears to be him, yes.
Okay, it appears that he has a broom in his hand.
Yes,
He appears to be brushing the driveway.
that's correct.
You don't have to guess that he's doing some work at Potomac on this day. You can actually see it.
That's correct.
This looks like it's the lumber. Were you able to see that he left on that particular day?
Yes, sir.
All right, thank you, Detective Johns. Detective Johns, in evidence, if I represent to you that on September 11th, Mr. Fernandez goes back to Potomac, is seen on video, would you dispute that?
No,
If I told you on September 13th that he went back and he did that, would you dispute that?
no, sir.
I told you at the very onset of this exercise that in the very first 30 days that you put up a poll camera, Mr. Fernandez was at that home doing work 20 times. And did you see that when I showed it to you?
Yes.
Your Honor, we can take that pause if you'd like at this moment.
All right. Members of the jury, because of some scheduling issues, we're going to pause Detective John's cross-examination, okay? He will retake the stand sometime later. So at this time, Detective Johns, again, I'm going to remind you of the rules that this court put into place, okay? And you may step down, and I'll be back with you shortly, okay? All right, members of the jury, we need just a moment to set up the courtroom, and I'll bring you right back out, okay? Leave your notepads on your chair.
Is it likely to be today, you think?
One second, just stay there. All right. Please let the record reflect that the jury left the courtroom. So Detective Johns asked me a very good question, which is, do you think you'll get back to him today? So it's, okay.
Good.
All right, so you can go walk around. Just stay in contact with the lawyers so they can call you, okay?
We're going to call 3 witnesses for all of them.
All right. Okay, go ahead and set up the Zoom, please. Are you doing Zoom first? Yes. Okay. I'm sorry, everyone may be seated. I don't think I said that. Sorry. Just from an IT perspective, is this being pushed out too? Okay. I'm going to...
I'm going to bring the witness into the room. Yeah.
Okay. Before we get started, is it by agreement that the witness can testify via remote technology? Mr. Dreiser?
Yes, my understanding is we've already signed a written stipulation to that effect.
All right. And it's, okay.
Ms.
Before we
Kudus,
get-
I'm sorry.
I'm sorry, go ahead.
I was just going to let her know that we are in the open court now. We're about to begin your testimony. The jury's outside the courtroom. So unmute yourself if, I guess, IT can do that.
All right.
Okay, good. You should be good to go.
Is it Kutis?
Do a test, please.
Yes. Hello. This is Taylor Kudus.
All right. Ms. Kutis, just for record purposes, let's go on the record, please.
Yes.
I want to make sure that where on your device, is it a computer?
Yes, Your Honor.
Okay. Can you see the courtroom in full?
Yes, I can see you straight on, and then I can see the attorneys, like their backs are facing to me.
Okay.
And the people directly in front of you.
And where Mr. Fernandez is sitting, he can see the witness? Is that right?
Needs to be on those screens.
I can see him as well.
Okay.
I'm going to.
Can the defense see the witness? All right, that's all acceptable? Okay. All right. And then I'm going to read the, hold on, let me pull it up. Okay. I'm ready if you all are.
I'm ready.
Both sides ready? Okay, let's bring in the jury, Mr. Holman. Thank you. All right, welcome back in. Everyone may be seated. Members of the jury, just as I indicated before you left, we have paused the testimony, the cross-examination and the testimony of Detective Johns. If the state would call its next witness, please.
Your Honor, the state calls Taylor Kudus to the stand.
All right.
Virtually.
Okay. All right. Ms. Kudis, if you would please raise your right hand to be sworn in.
Ma'am, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. Ms. Before the state begins, members of the jury, Ms. Kudis, by agreement of parties, has been allowed to testify via remote technology. You are to accept her testimony as if she were here in the courtroom. And so before she begins her testimony, can all the jurors see Ms. Kudis on their screens? If you can answer out loud. Yes. Okay, perfect. You may proceed.
Thank you, Your Honor. Ms. Kudis, can you hear me?
Yes, I can hear you.
Good afternoon.
Afternoon.
Could you please state your name for the record?
It's Taylor Alexandra Kudis.
And could you spell your last name for our court reporter?
It's Kutis.
And Ms. Kudis, what state are you currently living in?
I live in Tennessee.
And what do you do for a living?
I am a corporate sales trainer for a company called Corpay.
Are you married?
I am.
And what does your husband do for a living?
My husband is in active duty military. He's in the Army.
And do you know the defendant in this case, Mario Fernandez-Saldana?
I do.
On your Zoom screen, can you see Mr. Fernandez? And if so, could you please identify him by what color suit and tie he's wearing?
Yes, I can actually see the back of him. He looks to be wearing a gray suit with a white shirt underneath.
Okay.
I can see the back of his head.
If you're looking, you can see the judge straight in front of you. Which side of the courtroom is he seated on?
He would be on my left, there, the judge's right.
May the record reflect the witness has identified the defendant.
Is that the only camera view you have, Ms. Kudis?
Yes, Your Honor. I can kind of see like above, so I can see the backs of like the defense, and then I can see you straight on, if that.
So she's not identifying by face?
I can see his face on my Zoom camera. That's why I asked.
Is there another angle? Should I like click over to my different camera options to see? Okay. I can see him on the Zoom room camera 4.
Yes. Can you see his face on Zoom room camera 4?
Yes, I do.
Okay.
Is that the person you identified as Mario Fernandez?
Yes, it is.
Thank you.
Okay. Yes, it may reflect that.
Thank you. And can you explain to the jury how it is that you knew Mr. Fernandez?
Yes. So I met Mr. Fernandez in 2013, 2015. I was in ROTC at Vanderbilt University, and we did a leadership training course in Fort Knox, Kentucky. And that is where I met him through that leadership training course. He was a drill sergeant at the time that we had that training.
And can you describe for the jury what the nature of your relationship was back in 2013 through 2015?
Yep. So we met at the training course, and then post-training course, a lot of the cadets and then like mentors, drill sergeants, we stayed in touch. And so we kind of developed a friendship outside of that. And then we just kept in touch over the years through phone and email and text and all the things.
And you answered the next question I was going to ask, which is how did you keep in touch? You said phone, email, texting. Have you ever visited in person since 2015?
I believe it was in 2015, the last time I would have seen him in person.
How often would you two communicate over the years?
I would say over the years, it was definitely intermittent. I was married previously, so, every now and then we would like catch back up. But I would say frequently over the years, but then there would be periods of time where we did not.
I want to talk to you about your relationship via text and phone and email with Mr. Fernandez in 2021 leading into 2022.
Yep. So just to provide context, my oldest daughter is adopted. I adopted her. So she's my stepdaughter. And at the time, when we were communicating in 2021, leading up to 2022, we communicated via text regarding just different co-parenting communications techniques to like have conversations. He was really good at kind of helping me work through some of those things that I was experiencing. And so that was kind of like the nature of our phone calls and things like that, was to just chat through some of the things that we were kind of both going through, I believe, at the time.
Just to clarify, at that time, you were married to your husband, your now husband.
I was married in 2022, so it was kind of leading up to, like, we were talking in 2021 and then leading up to when I did get married to my husband.
And the co-parenting relationship that you had going on was with your now husband that you were dating and his ex-wife.
Yes, correct.
And Mr. Fernandez was, did he also relate to you that he had a similar situation and that his wife had an ex-husband and they were co-parenting as well?
Yes, that is correct.
Did he ever discuss with you his wife's ex-husband, the victim in this case, Jared Bridegan?
Yes, just at time, like briefly at times, I believe he would just discuss maybe different drop-offs, just different situations that they were kind of going through.
How did he describe the nature of their co-parenting relationship?
I mean, he definitely mentioned that it was high conflict, difficult at times, I believe.
Did he discuss his relationship at the time with his wife, someone who may be known to you as Shanna Gardner?
Yes, he did.
What did he say about his relationship with Miss Gardner when you were having these conversations in 2021 leading into 2022?
From what I remember, he said they were kind of, you know, having some difficulties at the time, that maybe they weren't going to continue to be together, things of that nature.
Did he ever discuss with you his relationship with Miss Gardner's family?
I don't believe. Oh, yes, he did.
And what did he say? Maybe relationship's a strong word. Did he ever discuss Miss Gardner's family with you?
Yes, I believe he described his kind of his relationship with her as a contract between her parents that he had worked out with her parents, is what he referred to it as to me.
And when he mentioned that he had some kind of contract with her family, did he give any further details about what that could possibly mean?
No, he didn't really go into too much detail. He would just refer to it as a contract. And that was really all he said, didn't give a lot more context to that.
Did you ask him follow-up questions about that?
I don't remember exactly if I did, but I mean, I think he was just a little mysterious about exactly what that meant.
You said he was mysterious about it. Did he ever make comments to you about skills that he had?
Yes, at times he would mention that maybe his Army experience, he had like a special set of skills, or just that he had maybe different types of training that he described, you know, maybe he had, you know, from his time in the military.
And you knew that he briefly served in the Army as well?
Yes, correct.
The things he said to you about his Army service, did they make sense to you given what you knew from your husband, who's still an active member of the Army?
He just was very vague about the specifics of it. I knew that he wasn't like, so for context, my husband is a Green Beret. He's in the Special Forces. His extensive training took almost 2 years to go through. So when I learned that later on, just kind of comparing, I don't think that he went through the same training to be a Green Beret specifically.
At any point during our conversations with Mr. Fernandez in 2021 into 2022, did you perceive that he was interested in starting some kind of romantic relationship with you?
Yeah, I definitely think that there might have been some underlying tones there to maybe feel me out to see if there was any potential for like pursuing something with me. That's how it felt maybe.
Did you relay to him that you would be interested in that type of relationship?
No, I was not interested. I think that is kind of what ultimately led to when we ended communication with each other.
When was the last time you spoke with Mr. Fernandez?
I believe, I don't have exact dates, but I know that it was sometime in 2022. Definitely like February, March would have been like maybe the last time that we would have spoken via phone. But again, I don't have like exact dates.
That's fine. I'm not going to hold you to an exact date.
Okay.
We're not human calendars. I get that. When you spoke to him the last time or few times, did he ask to visit you in person?
He did mention visiting in person, yes.
And did you ever actually meet up with him in person?
No, we did not.
Did Mr. Fernandez in 2022 call you and tell you about the death of his wife's ex-husband?
Yes, he did.
Do you recall when he called you in relation to when the homicide occurred?
It was after. He called me we were talking, kind of chatting, catching up about work. Can't remember the exact context of the beginning of the call. And then he said that he thought that the kid's dad had died, and he thinks that it was a hit and run, was what he told me specifically.
And do you remember how close in time that was? Was the day after, a few days, weeks, months?
I believe that it was a few days after, but I'm not exact on that. But I know it was after it happened.
Did he give any more details other than it was a hit and run?
No, he did not.
Right. Thank you, Ms. Kudus. I don't have any further questions.
All right, thank you. Cross-examination.
Good afternoon, Ms. Kudus. Can you hear me?
Yes, I can hear you. I just can't see you, so let me... Oh, there you are.
So let's back up a little bit. You met him in 2013, is that correct?
I believe it was around that time frame, yes, sir.
And although you told the jury that you guys, kept up a little bit of a friendship, you didn't tell the jury that you actually had a little fling with Mr. Fernandez, a romantic fling.
We did have a fling back in, I guess it would have been that same time frame, 2013 to 2015.
Okay, and you would agree that's an important detail when the state then later asked you if he thought maybe he was pursuing you. You had a history where at one point he did pursue you, correct?
Can you ask that again? I'm sorry, I'm confused.
At one point in time, he did pursue you romantically, and it worked. And it worked. You were romantic with him for a brief period of time.
Yes, 10 years ago, yes.
Yeah. And then later, he asked sort of again if maybe you would be interested, correct?
Yeah, I believe that was kind of what his underlying tone maybe was in some of our conversations, yes.
And that was after he told you that things between him and his wife had sort of run their course, right?
I believe, I can't exactly recall like the exact timeline of how it all played out.
All right, well, let's go back through some timeline. Mr. Fernandez told you that he got married. He didn't hide that from you, correct?
Yes, he did.
And you knew that he was married for years, correct?
Yes.
And during that time, in your on and off friendship, you were having some co-parenting issues in your own personal life, correct?
Correct.
So you would contact Mr. Fernandez, and you guys would talk about that, correct?
Correct.
He didn't just call you to gripe about Jared Bridegan, his current wife's ex-husband, correct?
No, that was not.
You would be griping. I'm sorry, I didn't mean to interrupt you. You would be griping about your personal step-parent situation, and then he would talk to you about it, right?
Yes, I believe that was kind of both sides of it.
And in fact, you thought he was a valuable resource because you would contact him to get advice from him, right?
Yes.
Okay. So let's talk about this contract. Did you ever write any of this down, or is this all from your memory that he said something about a contract marriage?
This is all from just conversations that we had. It was not written down.
Right. So you're just recalling that he said something like this, but what you may or may not know, let me ask you, did you know that Mr. Fernandez was the trustee of the family trust?
I did not know that, no.
Did you know that Mr. and Mrs. Fernandez had a postnuptial agreement?
No, he did not refer to it to me as a post-nuptial agreement.
He may have referred to you as a contract, right? Because that's the word that you seem to have remembered, right?
Correct.
A postnuptial agreement is just a contract between two people on how they're going to separate their belongings. You agree with that, right?
Correct.
Okay, and you can't recall as you sit here today the specifics of what he was talking about in that contract situation, right?
He never disclosed the specifics of the contract. He just referred to it as a contract and, again, was aloof with those details to me. So,
did you ever ask him what he was referring to?
I don't remember if I asked him specifically. I just remember he reiterated that it was a contract. That was the word that stuck out in my mind.
Gotcha. But as you sit here, you don't recall whether you even asked him what he was referring to, right?
I don't. No, I don't recall the specifics, no.
And you don't remember the specifics of your conversations with him. And I think you've, in fact, told me before that none of this is for verbatim, correct?
Correct. I think just the timeline and like the specifics of conversation, I can't remember exactly what was said and when.
Right.
For that specific conversation regarding the contract.
Because you had a lot of conversations with him and you just don't have a recollection. That's because you didn't write anything down, right?
I don't think I did write anything down, no.
So let's be real clear about another concept. Mr. Fernandez calls and he tells you that Jared Bridegan died, and you recall that he said something about a hit and run, correct?
Yes, he did.
But again, you don't remember that verbatim, correct?
I do remember that stuck out in my mind. I do remember that he said those words.
Do you know if Mr. Fernandez knew the details of the homicide at that point, 1 or 2 or 3 days after the homicide?
All he said was they think it was a hit and run. That's what stuck out in my mind.
Okay. Did you know that the person who's responsible for this homicide ran away from the scene?
I don't know really any other details. I haven't followed.
Okay. But in fact, closely. In this particular homicide, this jury has since learned that the person who shot Mr. Bridegan ran away from the scene. You didn't know that, did you?
I think I knew some of the details. I think I knew that there was another individual involved, but I don't know like the specific nuances of like
all right, so
how it all played out.
And you know that not because Mr. Fernandez told you that. That's because you looked things up after Mr. Fernandez told you about Mr. Bridegan passing away or dying, correct?
I did look it up, yes.
Yeah, and you followed it in the media, correct?
Yes, I haven't followed it closely though.
All right.
Since, yeah.
But let me be real clear about this question. You never contacted law enforcement and said, you know what? I've read this stuff in the media. Mr. Fernandez told me some stuff about a contract and a hit and run. I think you ought to know that. That never happened, did it, Ms. Kudas?
I'm not sure I'm following what you mean.
Law enforcement contacted you, correct?
Yes, correct.
You never contacted law enforcement, correct?
No, I did not.
And when law enforcement finally did decide to contact you, when they did, you have previously told me it wasn't because you thought it had anything to do with this case, You thought it had to do with a personal issue in your own co-parenting case, your own family law case, correct?
When they came to our house in North Carolina, I was not aware or sure what it was. I did think that it had to do with my husband's ex-wife at the time, just because we were kind of going through some high conflict issues.
And even after you looked up this case, you never thought Mr. Fernandez was a suspect?
Well, when they came to my house and they asked to interview me about him, that told me that he was probably, or I believe the terminology at the time was, a suspect.
Yeah. That's when you learned it, which was many, many months after the homicide when they came to your house, correct?
Correct.
But you looked it up on the internet after Mr. Fernandez told you about the death of Mr. Bridegan, correct?
Yes, I think he told me as just like he passed, like he said it was a hit and run. They think it was a hit and run. Like, I don't think there was anything else to it than that. Like, so I looked it up after the fact to see what he meant. Like, what, if anything, was in the news about it. Like, I don't think that there was anything.
And despite all of that, before law enforcement came to your house many months later, you never considered him a suspect.
Objection, Your Honor.
Grounds.
He's asking for an opinion.
Sure.
What's your response?
It's literally her testimony. What someone... We need to approach the court reporter. I've asked this question before. I know the answer.
Okay, I'll hear you out, Ms. Adbar.
Madam Court Reporter?
May proceed.
Ms. Kunis, with all of the information that was provided to you from Mr. Fernandez, over all of the different conversations that you had, over all of the months and years leading up to the homicide of Jared Bridegan, you never thought to contact law enforcement and report any of those details to them?
I don't know what you mean. Like, what would I have reported to them? I guess I'm confused by your question.
You did not contact law enforcement and give them any of the details that you testified on direct examination to, correct?
No.
No, meaning that is correct. You did not contact law enforcement.
I did not contact him after he told me no.
Or any time until they came to your door, correct?
Correct.
All right, no further questions. Thank you.
Redirect.
Once again.
Ms. Kutis, when law enforcement came to your house, you thought it significant enough to tell them the information you've testified to today?
Yes, correct.
And just to clarify, you remember you said specifically the word contract stood out to you, not a post-nuptial agreement, but the word contract.
Yes.
And you also specifically remember he said it was a contract with her family, not with her.
Yes, with her family specifically.
And he had this conversation in the context of also mentioning these special skills he had from his time in the Army.
Yes.
Yes. And when he described the death of his stepchildren's father, he said it was a hit and run, but did he ever tell you that Jared Bridegan had been shot and killed?
No, he did not. He just used the words, they think it was a hit and run. That is what stuck out in my mind.
Okay. Thank you, Ms. Kutis. I have no further questions.
All right, thank you. Make sure you be excused. All right, Ms. Kutis, thank you very much. I'm sorry?
Do I need to show my ID or anything, or?
Oh, no, you're fine.
All right.
All right, thank you very much. You can log off. And state, you want to call your next witness? All right, Victor Quiris, we're going to allow him to go into the Zoom room. Members of the jury, while we are having him come into the Zoom room, the same instruction applies to his testimony by stipulation of the parties. The parties have agreed that he may testify via remote technology. If you would just give us a moment so that we can check the sound, okay? Mr. Quiros?
Yes.
Hello, I'm Judge Kite, okay?
Oh,
can you hear me?
Yes, I can hear you.
All right. Can the members of the jury see Mr. Quiros? If you could answer aloud. Yes. Thank you. All right, please raise your right hand to be sworn in.
Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And can the defense see Mr. Quiros, okay? All right. You may proceed.
Good afternoon. Can you hear me okay, sir?
Yes.
Could you please state and spell your name for the record?
My name is Victor Quiros. It's Victor. Last name is Quiroz.
And Mr. Quiros, can you see the various Zoom rooms on your screen?
Yes.
You can see more than one Zoom room.
Correct.
In any of those rooms, do you see an individual known to you as Mario Fernandez?
Cam 4, yes.
Okay.
Maybe. Yeah.
Camera 4, and may the record reflect he's identified Mr. Fernandez.
Yes.
Mr. Quiros, I want to talk to you about your relationship with Mr. Fernandez. Could you please tell the jury how it is you know Mr. Fernandez?
Well, I met him through a high school friend playing a video game online. So that's how we met. And most of our conversations just been through video games online.
And what year did you meet him online?
It's hard to say. I think maybe 2010 or maybe around that time, yeah, 2010.
Okay. And I'm asking you very few questions. I'm going to be asking you about an in-person visit you had with Mr. Fernandez in March of 2022. Okay?
Mm-hmm. Mm-hmm.
And for our court reporter, because you're on Zoom, would you mind answering yes or no? Because it's very hard for her to type down mm-hmm or mm-mm.
Sorry, yes.
No problem. Thank you. Prior to the visit that I'm going to speak to you about, had you ever met Mr. Fernandez in person?
No.
And your contact, you said, was mainly communicating through video games. Can you describe for the jury what type of video games you're talking about?
I mean, well, those since then it was mainly Destiny. We played a assortment of games. I mean, mostly Destiny, Apex, COD, whatever was popular at the time.
And these are games that allow you to play with other individuals who are logged into the same game and communicate by a headset or chat feature or whatever.
Yes.
Okay. Was most of your contact with Mr. Fernandez through those video games?
I would say so, yeah.
Did you all text, email, or speak on the phone outside of the video game platforms?
Mainly through just Facebook Messenger. Like we would text each other, hey, who's on tonight? Stuff like that.
Drawing your attention to March 2022, where were you living at the time?
Still at my current address in Clinton, North Carolina.
Okay, and you don't have to put your address on the record, but you are in Clinton, North Carolina, is that what you said?
Correct.
And you were living in Clinton, North Carolina back in 2002?
Correct.
Did Mr. Fernandez...
2022.
Yes, sorry, 2022. Did Mr. Fernandez reach out to you in 2022 and arrange to meet up in person?
Not necessarily. I think it was like the weekend beforehand. He maybe like gave me a heads up. He was coming up north, and I kind of, said, hey, that's cool. If you need somewhere to crash out, I'm kind of on the way there. If it's not too far out your way, and it's pretty much. I mean, I don't remember what day it was specifically we met, but it was a weekday.
Did you know Mr. Fernandez was coming to visit you before he arrived in Clinton, North Carolina?
Like I said, the weekend prior, I think he did say like he was going to be in the area, so that was like the only notice I had received. Well, he had told both of us, me and my other people in the group chat there.
Mr. Quiroz, could you repeat the answer?
Yeah, no, it was just the weekend ahead, or the weekend before he came was whenever I believe, texted and said he was going to be in the area or something like that. And then I said, I'm working, but, if we can work it out, you can stop by, then just stop by. It's cool. It wasn't any problem with me.
Mr. Quiroz, do you remember giving a deposition in this case on Zoom?
Correct, yes.
Do you remember being sworn in to tell the truth the same way you've been sworn in here today?
Yes.
And at that deposition, do you remember being asked questions by Mr. Fernandez's attorneys?
I don't know who was asking the questions, honestly, but yeah, I do remember some questions being asked.
Do you remember being asked previously if Mr. Fernandez had told you ahead of time he was going to be in Clinton, North Carolina?
Yeah, I don't think I mentioned it that time, just because I didn't, like I said, it was hard to recollect, but I kind of, since then, I kind of been thinking back, and I believe he did text me, let me know he was coming ahead of time.
Ms. Stifler, can you refer to what page in the
I haven't gotten there yet. Yep, just doing the foundational questions. So your testimony today is that you previously told defense and myself, and I will refer to your deposition.
Yeah, I didn't get it.
Sorry, sir.
I'm
Sir,
sorry.
hang on one second real quick. I got to let defense know what page I'm on.
wanted to comment about that deposition.
Hold on just 1 second.
All right, Mr. Quirs, you said that
Yes.
you did not mention it at the deposition, but you remember today that he gave you a heads up he was coming to visit?
Yeah, and like I said, I wanted to comment on that deposition just because I just received it last night. I didn't really get a good chance to look over it. Like I said, I was told the last 3 weeks I was gonna get it sent. I never got it. I just received it last night. I mean, like I said, I was kind of been thinking ever since that day what exactly was said, but I can't remember. Like I said, I mean, like the deposition could be, you know, I don't know. Like I said, I didn't get a chance to review the deposition very well. So
Okay.
I don't know.
Your
Like I said,
testimony today is you now recall Mr. Fernandez telling you he was going to come visit you ahead of time.
Objection, Your Honor, improper impeachment.
I'll overrule it.
You can answer the question. Your testimony today is you now recall Mr. Fernandez gave you advance notice he was going to visit you.
Yeah, like I said, the more I think about it, you know, thinking back, I think he did shoot me a text before he came, or shoot both of us a text in the chat, and both of us were working, or it was 3 of us in the chat. So he texted, and I think the other 2 were like, yeah, well, I'll be working, and where I work, I don't, you know, have a set schedule. So I told him, you know, hey, if you're in the area and we can work it out, you know, okay, we'll meet up.
Did you meet up with Mr. Fernandez when he was in Clinton in March?
Yes.
2022.
Mm-hmm.
Did he tell you anything about the reason that he was in Clinton, North Carolina?
The only thing that he said was he was going up north to see a friend. I don't remember. I mean, he didn't say any name or what state. I don't remember exactly what state it was up north, but that's the only thing he said was his reason for coming up north.
Did he have any conversation with you about the homicide of an individual by the name of Jared Bridegan?
No.
The father of his stepchildren?
No.
He didn't mention to you in March of 2022 that his stepchildren's father had been killed?
No. We didn't. That never came up in conversation.
And you have your deposition, you say you reviewed it. And for
I didn't get a good chance to review it. No, I'm a family man. I got it really late in the evening. It was after 5 o'clock when I received it. You know, we do dinner, we have homework. You know, I've got 3 children that need attention, so I did not need a good chance to review it. No, ma'am.
Okay. Well, do you have it in front of you? I can refer you in court and counsel to page 19, lines
Yes,
21, going to
here.
page 20, line 5.
Your Honor, may we approach with the court reporter?
Yes. Page, just give us 1 moment. I think she said page 19 if you want to go to it.
Okay.
ever mentioned to you or discussed the fact that his wife's ex-husband had been murdered in their neighborhood?
Are you talking about when he came to visit March 13th, or I mean, I don't understand the question because
I'm talking
when
about, sorry, I'm talking about any conversation you had with Mr. Fernandez. Did Mr. Fernandez ever discuss the death of Jared Bridegan with you?
He did, but it wasn't when he came to visit. The day he came to visit, it was not discussed.
Okay. When did he discuss the death of Jared Bridegan with you?
I couldn't tell you an exact date. I just know it was one day we were playing the video game. He mentioned it, and I think there were multiple people on the game. You know, he said what had happened, and he logged off shortly after.
What did he say happened, as best you can recall? And I understand you can't quote him word for word.
Yeah, I mean, this is me paraphrasing, but I think he said something along the lines that he had been shot. That's all he said.
When Mr. Fernandez visited you in March of 2022, did he tell you that he had been at the police station giving them an interview?
No.
You had no conversation in March 2022 about anything to do with the murder of Jared Bridegan?
No, ma'am.
He didn't mention it at all?
At all.
Okay. I have no further questions, Your Honor.
Cross-examination. Give counsel just a moment to get on the screen for you.
Good afternoon, sir. Can you see me?
Yes, Cam 3.
Nice to meet you. My name's James Hill. I represent Mario Fernandez. How are you today?
I'm doing good.
Thank you for being here. Ms. Stifler asked you a bunch of questions about Mr. Fernandez. I believe you said you've known him since approximately 2010. Is that correct?
Yeah, I mean, yeah. I mean, as far as you can get to know somebody on a video game, yes.
So in 2022, you had communicated with him for over a decade.
On and off. I mean, we didn't play every day together. There was times where I didn't play. I mean, we would go. I think there was a span there where I didn't play with him for 5 years or so. I don't know. But we kind of it was a span of we didn't play together, and then when Destiny 2 came out, we kind of the group got back together. So it was like I said, there was a span there where I didn't communicate with him at all.
Admittedly, I'm not a big video game guy anymore. I got 3 kids of my own. But when you guys were playing, is this like on a headset and you guys are in gaming chairs and you communicate through the headsets?
Correct.
Okay, and it's usually with a group of people playing these games?
Correct.
Okay. So after 10 years of playing, you wouldn't consider Mr. Fernandez a stranger to you?
I wouldn't say a stranger, no.
You were comfortable enough inviting him to stay at your home if he needed to?
Yes. I mean, I like I said, I knew he was in the area, and I offered out. You know, I told him, don't even bother getting a hotel. If you can crash with me that night, you know.
And I'm somewhat familiar with Clinton. It's not a tiny town. There's hotels and motels in the area, correct?
Correct.
And certainly, if you didn't feel comfortable with him staying at your home, you could have asked him to stay at a motel or a hotel.
Exactly. I mean, if I had any inkling or any sort of suspicion of anything, you know, like this happening, I would never even invited him to my home.
Okay. But at the time, you had no concern at all. He stayed at your home, and you guys went out to dinner that evening, correct?
Yeah, we went out to dinner, came home. It got late in the evening, and I think he left early the next morning.
Okay. You guys went to Ruby Tuesdays?
Correct.
Okay. Had dinner, public place?
Yep.
Okay. I know Ms. Stifler asked you whether or not he talked about the death of Mr. Bridegan, but let's talk about some of the other stuff that he didn't talk about. Did he ask you to drive him about an hour away to Raleigh to go to the international airport so he could get out of town?
No.
Okay. Did he ask you to switch cars with him so he could try to evade law enforcement?
Not at all.
Okay. Did he ask you to give him a pile of cash so he could lay low?
No.
Okay. Seemed like just a regular guy hanging out with you at Ruby Tuesdays?
Yeah, just one of the dudes. Yeah.
Didn't say anything strange or alarming to you, did he?
Not at all.
Okay. Nothing in your conversation struck you as odd?
Not one bit. I mean, we talk sports, we talk video games, we talk construction. We both have small construction projects we were working on. So, you know, like I said, just a dude. I mean, we sat at the bar, had a couple of drinks, went home, and that was the gist of it.
All right, Mr. Quayres. Well, I appreciate you taking time away from your family and your work. I don't have any further questions for you, sir. Have a good day.
Any follow-up?
Thank you.
Last question, Mr. Kiers, and then we'll let you get out of here, okay?
Mm-hmm.
You just testified that you offered to let Mr. Fernandez stay at your house. You made that offer when he was with you in Clinton.
I mean, I don't know if there was maybe a small conversation beforehand. I don't like the day of or maybe the day before. I don't know. I just told him, hey man, you can crash in my place if you need. Blah blah blah.
Another conversation that may have happened that you didn't remember until today.
Well, no, these questions weren't asked before.
Okay. Your Honor, the witness may be excused.
All right. Nothing further for him from either side?
No, Your Honor.
All right, thank you, Mr. Quiros. You can log off.
Okay, thank you.
Members of the jury, you have one more? We need to switch back over really quick.
Yeah, now on Zoom, we have a live witness, Your Honor.
Do you need the cart?
No?
Okay, all right. All right, yes. No, it's fine. I don't want him sitting, I don't know where he is, and he can go now and then come back. Thank you. Sure. You can bring the gallery back in. Detective Johns, the state's going to call another witness, and I think it will take us to the time, so there's no need for you to stay. We're just going to start back with you at 9 a.m., okay? It will be 9 a.m., even though they're requesting some kind of hearing, but I'm not going to do the hearing, okay? I'm going to hopefully finish your testimony tomorrow, okay? For the record, I'm going to still admonish you, meaning just remind you that you are still on the witness stand. You cannot discuss your testimony with anyone. Do you understand that? Yes, ma'am. And you'll abide by it? Okay, thank you. I'll see you tomorrow morning at 9, okay? Thank you. Okay. Everybody, is everyone ready to go back on the record?
State's ready, Your Honor.
Okay, let's bring in the jury. Thank you. All right, welcome back in, members of the jury, and everyone may be seated. Members of the jury, the state is going to call their final witness for scheduling purposes, and then after this witness, we'll break for the day just so that you know what the remainder of the schedule is. I'm again going to remind you that we pause the testimony kind of midstream of Detective John, so we'll start back with him in the morning, okay? All right, you may proceed.
And please the court, Glenn Farag.
Glenn Farag. Good afternoon. All right, if you please raise your right hand to be sworn in.
Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
All right, thank you. This way, sir. You may proceed.
May it please the court. Please introduce yourself to the jury.
My name is Glenn Farag, F as in Frank, A-H-R-I-G.
How do you pronounce your last name?
Farag.
Welcome to Jacksonville. Could you please let the jury know what you do for a living?
Good afternoon. I work as a forensic biologist at the Forensic Science Lab in Washington for the Bureau of Alcohol, Tobacco, Firearms, and Explosives, otherwise known as the ATF.
How long have you been so employed?
I've been with that laboratory since November of 2017, so almost but not quite 9 years.
And during the course of your experience in working for the ATF Forensic Biology Unit, have you been allowed to come into courts like this one and provide your expert opinion in the field of STR DNA technology and the statistical component to that?
Yes, I have previously testified to the work that I've done.
And Your Honor, this time I would tender, without going through his entire training and background, for potential voir dire as to this qualification.
Any questions?
No, Your Honor.
Okay, thank you. You may proceed.
So since you've been testifying as an expert in DNA, could you explain to the jury what deoxyribonucleic acid is and why it's important forensically?
So DNA, or deoxyribonucleic acid, is something that's found within the cells of living organisms. You can think of it like a set of blueprints or instructions that tell a living thing how to develop and grow. It can be useful in a forensic context because there is some variation between individuals with regard to their DNA, so that we can use it to distinguish between individuals. It is fairly consistent throughout the body, so if your body produces it, it doesn't matter what type of sample it is. If the DNA comes from sweat or from skin or from bones or from teeth, the DNA profile is expected to be consistent throughout an individual. The DNA is also persistent over time, so that if we test DNA from an item from a crime scene and then months or years down the road we test DNA from an individual and do a comparison, we expect that DNA to retain its properties over time.
In other words, your DNA doesn't morph as you age.
Right. Your DNA is not expected to change with respect to the markers that we test and the profiles that we obtain as you age.
So the forensic differences that you look at to distinguish between individuals, are those locations on the DNA molecule, do they code for things like hair color, eye color, things like that?
We do a type of testing that's referred to as STR testing. STR stands for short tandem repeats. These are sections of DNA that do not code for physical characteristics.
So how, you briefly mentioned that DNA can be found in all of your cells. How is it left behind at a forensic scene? You mentioned some of those things, but just explain how it's left behind.
There can be a couple of factors that determine how exactly a DNA profile is left. There's a phenomenon which we would refer to as touch DNA, the idea that someone can touch or handle an object, and without saying with absolute certainty where the source of that DNA is from, it's possible that there are material from the skin cells that could be deposited. There could be secretions from the skin layers that could be deposited. There could be, if somebody has habits of touching their face or touching the area around their mouth, DNA could be moved around. But the idea is, however the DNA arrives and is deposited on an item, there is this concept of touch DNA where something could simply be handled or touched and leave but not behind enough material that somebody could come behind and test that item and get a DNA profile.
So in addition to touch DNA, is leaving your blood behind, leaving your spit behind, leaving your semen behind, do things like that, is that how DNA can be left behind in a scene?
Yes, we can also test bulk fluids, relatively large deposits or stains that could also have DNA that can be detected and characterized and compared.
Is it fair to say that what you refer to as bulk fluid, that contains more DNA molecules than touch DNA can?
In general, I would say so, that the amounts of DNA that might be expected with something like blood or saliva would be generally higher with respect to samples that we would characterize as a touch or a trace sample. But that's speaking generally. That's not to guarantee that, sample to sample, there's always variation.
Is DNA fragile, meaning that, like, just because someone touches something, does that automatically mean that they leave their DNA behind?
I can only speak to what is recovered when we do our testing, the results that we get. So just because if we knew for certain that someone did handle an item, it's not necessarily guaranteed that we would be able to test that item and recover results that would be consistent with that individual.
Do elements like heat, dirt, water potentially destroy or wipe away DNA?
There are a variety of factors that can influence whether or not DNA is damaged. So DNA can be what we call degraded, which is damaged over time. So things like heat, moisture, mold, bacteria, they can damage the DNA, which can impact and negatively influence our ability to get DNA profiles. And then DNA can be lost. It can be wiped or washed away.
So when you do your testing, when you have unknown samples and then known samples, did you do both of those types of testing in this case?
Yes, an unknown sample would be a type of sample where if a DNA profile is recovered, the origin of that profile is unknown. So any type of crime scene evidence, something like a swab from a firearm, a swab from a vehicle, those types of things are what we would characterize as unknown or questioned or evidence items. And we contrast that with reference samples or known samples. And these are samples that are taken directly from an individual and are what represent their known reference profile. Those generally come in the form of an oral or a buccal swab. BUCCAL is a buccal swab, or sometimes we will receive blood samples where they'll draw a sample of someone's blood and deposit it on a card.
And so what is commonly done, and you do in this case, is you have these known or reference samples, and then if you develop DNA on one of these unknown samples, you compare the two to see if they are consistent.
Correct. That is the ultimate aim in trying to do a forensic DNA analysis, is we want to test the questioned evidence items and try to obtain whatever DNA results we can. There's a point at which we will determine if we do get a DNA profile, does it meet our lab's criteria to be suitable for comparison to references or not suitable for comparison to references. If we do have unknown profiles that are suitable for comparison, then we will take any known reference samples that we have and we will compare the profiles of those individuals to the unknown profiles and see if we can make determinations supporting either inclusion or exclusion of the individual as a contributor.
Is it common in your training experience to examine an unknown item and not find any DNA at all?
It is possible that we would test an unknown item, and some of the conclusions we may draw is one of the lab steps. We will estimate how much human DNA is present in the sample, and sometimes we do not detect any amount of human DNA present, and we would characterize that as no DNA detected. There are times where we might test a sample and there may or may not be an indication of human DNA present, but when we do the last step in our process and process the sample on the detection instrument, we get no detected data, and we would report that as no results. So those are some of the conclusions we might reach where we test a sample and we don't actually obtain DNA results.
And is it common in your training experience to actually find some amount of DNA, but that DNA is just not suitable for inclusion or exclusion?
Right, that is one type of conclusion we might reach as well. We might develop DNA results and observe a profile, but the profile may not meet our criteria to be suitable for comparison. So we'll make that decision. The profile is either determined to be suitable for comparison, it might be determined to be not suitable for comparison, and some profiles, occasionally with mixture samples, a mixture is a DNA profile that appears to come from more than one person, we may separate that into two separate components, which we would refer to as a major and a minor component. And within the context of a mixture at our laboratory, the major component is the part that is suitable for comparison. The minor part is the part that's not suitable for comparison.
Thank you for that explanation. Did you bring your file and review your reports in this case?
I did review the file and my reports. I have brought some selections of some copied materials in case I might need to refer to something.
I'm going to try to go through this fast. We're not going to ask you everything that you did, so just kind of follow my lead and we'll get through this. The most important question, I guess, for the state of Florida versus Mario Fernandez is, during the course of your comparison, did you find any of Mario Fernandez's DNA on any of the unknown samples that you tested?
We would never say with any certainty that we found someone's DNA on an item or that a person is definitely a contributor. What we would describe our results as is there support for inclusion of this person as a possible contributor? And to summarize the results from this case with respect to Mr. Fernandez-Saldana, of the unknown profiles that had components or were entirely suitable for comparison, there was no support for inclusion of Mr. Fernandez-Saldana as a possible contributor to the components that were suitable for comparison.
Same question with regard to Shanna Gardner. There was no inclusion of anything that you tested of her.
Same characterization with respect to the comparisons to Ms. Gardner. There was no support for inclusion of Ms. Gardner as a possible contributor to the suitable components of profiles that were suitable for comparison.
Or any of the police officers that you got known samples for?
Correct. We received a number of elimination samples from various law enforcement officials, and there was no support for inclusion of any of those individuals to any of the suitable components of profiles that were suitable for comparison.
Or Justin Bridegan, the brother of Jared Bridegan, no inclusion there?
There was no support for inclusion of Justin Bridegan to any of the profile components that were suitable for comparison.
Two more names, Jeremy Ordway and Jimmy Jones. Same question.
I know we received a reference sample from Mr. Ordway. I'm not sure about Mr. Jones. Could you refer to an exhibit number?
Yeah. It may take me a second. We'll go on to another part. My co-counsel can find that.
I can't answer with respect to Mr. Ordway that there was no support for inclusion of Mr. Ordway as a contributor to any of the profile components that were suitable for comparison.
So, of all the items, and there were many items you tested that did not either have enough DNA or had no DNA. Is that fair?
So some of the items may have been described as no DNA detected, which is where when we do that step where we estimate how much human DNA is in a sample, we did not have any detectable level of human DNA. There were some samples that fit that description. There were also some samples where we processed those samples on the detection instrument and there was no detectable signal, so those were no results.
So now we're going to get to the things where we do find matches. Beginning first, I'm going to talk about the shell casings number 3 and shell casings number 4. Did you find that there was an inclusion with regard to the victim, in this case, Jared Bridegan?
So those items in question, these are 2 10-millimeter cartridge cases recovered from the scene, assigned lab exhibits 3 and 4. We will sample cartridge cases in pairs on occasion, which is what was done in this case. So lab exhibits 3 and 4 were sampled together. That resulted in lab exhibit 3.1. That sample was processed and there was a profile obtained from exhibit 3.1 consistent with being a male DNA profile consistent with a single contributor. Upon comparison to the reference samples in this case, there was support for inclusion of Jared Bridegan as a possible contributor to that DNA profile.
Was there a statistical component that you would assign to show, to give the jury an idea of how forensically important that inclusion was?
So when we report any conclusion as a result of a comparison that is anything other than exclusion, we will report a statistic that is known as a likelihood ratio. A likelihood ratio is a value that can give weight or give support to either inclusion or exclusion of an individual. It is an assessment of how probable the evidence profile is under different possible explanations. One explanation is what we call the inclusionary hypothesis, and this is where we assume that the person we're comparing is a contributor to the profile. The other explanation is what we call the exclusionary hypothesis. This is where we propose that the person of interest is not a contributor, that other unrelated, unknown individuals could be the contributor. So when we do the comparison between Jared Bridegan and Exhibit 3.1, the likelihood ratio value is that it is at least 1 trillion times more likely to observe the evidence profile from Exhibit 3.1 if Jared Bridegan is the contributor than if an unknown, unrelated individual is the contributor.
I'm showing you what's been entered into evidence as State's Exhibit 94. You can see on your screen, State's Exhibit 88C and 88D. You see those? I know they're all bunched together, beginning first with 94. This has been introduced into evidence as the victim's blood spot card. Is that where you developed the full profile from Jared Bridegan? If it's easier for me to just show it to you the whole.
Maybe if I look at it myself, yes.
I don't know why I'm saving steps. Sitting all day.
So it may be useful at this juncture to point out that at our laboratory, as the forensic biologist, I won't necessarily do all the work in the case myself. We do have lab specialists that assist us with laboratory tasks, and sometimes examiners will do various laboratory tasks for each other. I am the one who's responsible for all the analysis of the data and the reporting. And I bring that up because I see this exhibit, which is ATF and also Lab Exhibit 18, which is the reference sample from Jared Bridegan. This is not a sample that I actually received myself, but I do see the handwritten initials of the lab specialist that did process this item.
Okay, and then showing you 88C and 88D, the shell casings. Now, my understanding is those shell casings went through a process to extract DNA different from the normal swabbing. Is that true?
That is correct. At our laboratory, we used a specialized sampling technique known as the rinse and swab technique to recover DNA from fired cartridge cases. It is a technique that we developed in-house, and we published our research in a peer-reviewed research journal. As I look at these evidence packages, I see the lab specialist's handwritten annotation indicating these are lab exhibits 1 and 4 that correspond to 2 of the 10-millimeter cartridge cases.
Thank you, sir. So the jury has already seen the crime scene photos, and there's no reason to publish those again. But you'll have to kind of stay with me for this analogy. So the jury saw pictures of the deceased Jared Bridegan on the ground. He was bleeding heavily. They heard testimony that the victim was moved during the course of CPR. In other words, first responders got to the victim who was face down. They rolled him over. They performed vigorous CPR, and the victim was bleeding everywhere. They also saw that these shell casings were all collected in the immediate vicinity of the victim, meaning within inches to a few feet away from the victim. Is the finding of the victim's DNA on these shell casings consistent with the DNA being deposited on the shell casings after those shell casings had been fired and left onto the ground where Mr. Bridegan was found and CPR was performed upon him? Understand my question?
I heard your description. I don't know what the question is. I'm sorry.
The question is it consistent with your training and experience that the victim's DNA could have been transferred onto the shell casings after they were expelled from the firearm because the victim who was moving around, bleeding, performing CPR, and the collection of the shell cases all happened in the same area? Is that consistent with your training experience?
I have to be careful how I answer this. What you're describing is what we refer to as activity, which is how we would describe how DNA is actually deposited on items. I don't really have a technique or a method to try and evaluate specific activities as far as trying to determine exactly how a DNA deposition could have occurred. What I can say, which is what is seen in research studies, which I've observed in my own training and in creating training samples for others and in doing my own research, is that when we have, controlled studies where a volunteer will handle or come into direct contact with an item, and then we test that item, we do obtain results that are consistent with an individual coming into direct contact with an item. As far as can I extend that to say with any certainty whether endorsing your specific scenario that you've described, I cannot do that. I do not have a method to do that.
I appreciate that because you're a scientist. My question is not whether that's how the DNA got there, just that is within the scientifical probabilities of the world that yes, if a bleeding victim and shell casings are all rolling around the ground, there could be some transfer there, possibly.
I would say in general, if an individual comes into direct contact with an item, it is possible to test an item and get results consistent with that individual.
Thank you, I appreciate that. So now we'll get to, I guess, the meat of it, which is, did you find any DNA consistent with the known reference sample of Henry Tenen?
There were a number of questioned evidence items that were tested that yielded results that were suitable for comparison. And on comparison to Mr. Tenen's reference sample, there was support for inclusion of Mr. Tenen as a possible contributor to some of the evidence items.
Turning to the swab taken from the inner rim of the tire, was that consistent with Mr. Tenen? And could you explain to the jury your statistical analysis on number 11, the swab from the inside of the rim?
So lab exhibit 11 refers to the swab from the inner rim of the tire, and the cutting of that swab and the sample that we generated is lab exhibit 11.1. There was a DNA profile obtained from exhibit 11.1. That was a partial DNA profile consistent with at least 2 contributors. This was further resolved into a major and minor component. The major component was a partial DNA profile consistent with a single contributor. The minor component was not suitable for comparison. Upon comparison of Mr. Tenen's profile, there was support for inclusion of Mr. Tenen as a possible contributor to the major component of Exhibit 11.1.
What was the statistical inclusion?
The likelihood ratio value for that comparison was that it was 1.38 million times more likely to observe the DNA profile from Exhibit 11.1 if Mr. Tenen were a contributor with an unknown, unrelated individual than if it came from 2 unrelated, unknown individuals.
Okay, turn to the swab of the keys, the silver key that you took. Did you include Henry Tenen as a possible contributor to that silver key swab, number 30?
Lab Exhibit 30 was the silver truck key, the sample that we took and generated the profile from, Lab Exhibit 30.1. That was characterized as a DNA profile consistent with 2 contributors with at least 1 male present, and that was suitable for comparison. Upon comparison with Mr. Tenen's reference sample, there was support for inclusion of Mr. Tenen as a possible contributor to that profile. The likelihood ratio was that it was at least 1 trillion times more likely to observe the DNA profile from Exhibit 30.1 if Mr. Tenen was a contributor with an unknown, unrelated individual than if it came from 2 unrelated, unknown individuals.
Turning to 33.4, the cutting from the steering wheel, were you able to include Henry Tenen as a contributor to that?
Lab Exhibit 33.4 corresponds to a swab from the steering wheel of a pickup truck. That profile was a partial profile consistent with 1 individual. That was suitable for comparison. Upon comparison to Mr. Tenen's reference sample, there was support for inclusion of Mr. Tenen. The likelihood ratio was that the DNA profile is at least 1 trillion times more likely if it originated from Henry Tenen than if it originated from an unknown, unrelated individual.
We'll do the same process. May please.
Yes, throughout.
Thank you. States Exhibit 9, we'll start first with States Exhibit 95. Is this the reference sample from Mr. Henry Tenen that you or your fellow lab people worked on?
This sample I did initial myself, and I see our lab inscription and lab number. This is Exhibit 26, the reference sample from Henry Tenen.
Okay, and that's going to be States Exhibit 95. All right, States Exhibit 92 is going to be the swab from the inside rim of the tire.
All right, I see the handwritten inscription from the lab specialist who assisted with this case. This is Lab Exhibit 11, the swab taken from the inner rim of the tire.
States Exhibit 193 is going to be the swab from the silver key.
I see the handwritten annotation from the lab specialist, and this is Exhibit 30, the swab from the silver Ford truck key.
States Exhibit 169 is going to be the swab from the steering wheel.
I see my handwritten information. This is Exhibit 33, 4 of 13. There were 13 swabs submitted as part of Exhibit 33, and this is number 4 of 13, which corresponds to the swab of the steering wheel.
Sir, I appreciate your testimony. I have no further questions at this time.
Thank you. Cross?
Just briefly, Your Honor, may I do it from defense table?
It's fine.
Good afternoon, sir.
Good afternoon.
I didn't catch, where did you come in from?
I work at the Forensic Science Lab, Washington, which is located in Maryland, just outside D.C.
You flew in today, sir?
I came in yesterday afternoon.
Welcome, Jacksonville. I just want to make sure the jury's clear. You found nothing to include Mario Fernandez, is that correct?
Of the profiles that were suitable for comparison, there was no support for inclusion of Mr. Fernandez-Saldana as a possible contributor to any of those profile components suitable for comparison.
Thank you, sir. I have no further questions.
All right. Any follow-up?
No, Your Honor.
Okay. May the witness be excused.
You may.
All right. Thank you.
Thank you, Your Honor.
All right. Members of the jury, that will be the last witness of the day. I ask that you leave your notepads on your chair. We'll see you tomorrow morning at 9 a.m. Please follow the communication rules. All right, thank you. Everyone may be seated. Please let the record reflect that the jury has left the courtroom. I'd like to inquire of Mr. Fernandez. Do you need a moment with him? It's about the sequestration.
Oh, I do need a moment.
Okay, all right. Just let me know when you're ready. Sure.
We can go back on the record, Your Honor. We've had an opportunity to confer with Mr. Fernandez.
Okay, thank you. So just so the record is clear, I was at the point in time where I would have to enter an order to sequester the jury for deliberation purposes. In the planning of this trial that's been months and months in the making, we discussed it. And just so the record is clear, the clerk's office is prepared to do it. And so they asked for the funds. And so I was getting to the point where I would have to basically enter in an order based on the party's input about when we would be finished, because that was important, right? So, and I'm saying all this for Mr. Fernandez's benefit as well, okay? So I'm basically fast forwarding to near the end, and obviously the scheduling is largely up to the court. And once we give it over to the jury, we have no idea how long or how short it would be. It could be minutes, it could be days. And so we have to prepare for those things. And the clerk's office is prepared. So I inquired of the parties earlier, and I believe that the target date by all sides, I think you've been saying like maybe Thursday, finishing.
Yeah, Wednesday.
Thursday of
Wednesday
next
or
week.
Thursday, yes.
So that is what we were planning. And if the jury were to be sequestered, this is the process. And Mr. Fernandez, I'm explaining this to you, okay? On the day that the jurors would deliberate, what would happen is that the day before I would tell them, you have to pack your bags. Their bags would be searched, and searched not for, well, obviously contraband, but they would be searched for what we would consider contraband, something that could not be in a deliberation room, like crime mysteries, dictionaries, books, like that would somehow impact their decision in the case. They can have books, but they cannot be at all related to anything criminal or anything along those lines. It can be purely like entertainment, like a fantasy book. That could be a good example.
Bird watching.
Bird watching. And so those things would be allowed. The hotel would prepare individual rooms. The TV would be removed. The phone would be removed. And essentially they would go to the hotel. They would be guarded by the police. And they would have no outside contact until they came back to the courthouse to be back together. So to ensure these things, the reason why it's done that way is to ensure, number one, that somehow there's not some informal deliberation between the jurors when they're outside of court. They can only deliberate when all of them are together in a room. So that would short circuit that. And then, so that is the preparation that I'm going to ask you about, okay? So it's my understanding from the state of Florida that you're going to waive the sequestration, like if they, and this only happens, that is that hotel room, if they're unable to reach the verdict within a reasonable hour during the time frame of the day. So we wouldn't send them home. If they were sequestered, they'd go to this hotel under the conditions I've just described.
That's correct. Of course, with the court's instructions that they aren't to deliberate, they aren't to do any research. So we know the court would give those instructions.
I reread the whole thing, and I'd also tell them the thing that I always kind of exclude, which is that they could be held in contempt of court. They could go to jail. They could, all kinds of things that I could do to enforce that if they violated this court's order, I'd be prepared to give them the full force of this court.
So we have no objection to that process.
So the other thing, and that is a consideration that I'm sure your lawyers have talked about, at the time of deliberation, okay, so once the arguments are done, once the law has been read, and they are ready to deliberate, I let those alternates go, okay? I let them go because then the alternates only stay there to the point in time in which deliberation. There is no ability, okay, to, let's say one of them, okay, during deliberations does something, okay, that is against the rules, whatever it may be, hypothetically. I couldn't substitute an alternate at that time. You understand? Okay. So I'm explaining all this because there's considerations on both sides. The state has decided that they would waive that. So I'm going to ask that you raise your right hand to be sworn in.
Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Have you understood everything that I've said to you?
Yes, Your Honor.
Did you have any questions about the sequestration process? And it's only if they're unable to reach the verdict within the time period we give them, a reasonable hour, then they would go to the hotel, they would return back, they'd have a whole nother day, and it could happen as many times as it needs to. That means they go back to the hotel to reach a verdict. So have you had enough time? Well, let me ask you this. Do you have any questions about that process? I'm happy to answer any of them.
I have no questions, Your Honor.
Okay. Have you had enough time with your lawyers? Have they explained kind of, what I've just explained to you?
Yes, Your Honor, they have.
All right. And do you feel, my understanding from Mr. Dreiser, let me ask you, what's the defense position on sequestration?
We agree with the state that under these very particular circumstances that they do not need to be sequestered in the event that it goes into the late hour of the first day of deliberation.
Okay. So to be clear, they're going to go home with the court reading the communication rules, maybe in more full force than I did before. I mean, I've been reminding them, but I'd add in that, how critical this is, that they cannot violate this court's order. So the defense is comfortable with waiving that.
I'll let Mr. Fernandez answer.
Yes, Your Honor, I'm comfortable with it.
Okay. And so this is critical for me, just like it's critical when I excuse those alternates. If they don't sign this contract, that is the clerk's office, and I don't put these things into motion, it's kind of too late to recapture all of that. You understand? So I need to kind of know today. Do you need any more time to think about it?
No, Your Honor.
Okay. All right. Well, I will find that the waiver of sequestration by the defenses, and Mr. Fernandez in particular, is freely and voluntarily entered. So that will be the procedure. We won't sequester the jury, but they will be admonished the way that I've just described for the record. All right. So is there anything that we need to take up before we break for the day?
Your Honor.
Not from the state.
All right, thank you. And for the state's purposes, I've been emailed that the Gardner issue is going to be passed to noon tomorrow, okay? And then my plan is for the Fernandez trial, instead of starting late, I'm going to start right on time, and then I'm going to take a longer lunch break. I think they'd rather enjoy that with like food or whatever than being stuck in the back with just like coffee or whatever, okay? All right, court's adjourned.